Recording in progress.
Good morning, everyone. I am Demetria Frank, the Spring 2023 Herff Chair of Excellence and former inaugural Dean for Diversity and Inclusion at Memphis Law. I'm excited we are having these conversations today, especially considering what is happening at large and specifically here in Memphis involving police violence. Standing in a community that is mourning what we've seen too many times now, the importance of conversations about teaching topics that have traditionally been excluded from legal education seems even more important. Before we get into it, I want to thank our Dean, Catherine Shafson, who has been supportive and enthusiastic about this symposium since the initial idea of it. I yield the floor to her for a moment so that she can welcome you.
Good morning, everyone. Thank you so much, Dean Frank. I'm so happy to welcome everyone to our law school. I'm sorry that it's only virtual, but I have already seen so many friends from around the country log on that I know would not have been able to attend otherwise. So I'm so glad that you are all joining us this morning. This year's Herff Chair of Excellence Symposium follows closely on the heels of last year's really important symposium, which focused on critical race theory. That was led by then Herff Chair of Excellence, Dr. D.J. Jackson from the University of Wyoming School of Law. I'm really grateful that Dr. Jackson and so many of the panelists from last year's program will be joining us later this afternoon for Panel C to continue that conversation about critical race theory. We hosted last year's program boldly titled Critical Race Theory with the full support of the Memphis legal community while the Tennessee state legislature was meeting in Nashville to consider a bill which bans the teaching of divisive concepts in the state's public colleges and universities. That bill became law later last year, but it does contain an important caveat where accrediting bodies require otherwise. Thus enter this year's really timely topic, which is so critical to what we do at Memphis Law, and I know at countless law schools around the country, and that is ABA Standard 303C. Our accreditor requires the teaching of cultural competence, bias, and racism in our curriculum, and that provides an exception to the Tennessee Divisive Concepts Law. you can see why this is such an important topic to us here in Memphis so that we can continue our work. And I'm so grateful to all of our panelists who've joined us to help us explore how we can better incorporate these subjects into the law school curriculum. I have to take advantage of this opportunity, Dimitri. I think I'm only 90 seconds into my 2 minutes. I'm going to take a little bit. I'm going over, I'm just going to tell you, but not by much. I have to take this opportunity to recognize our Herff Chair of Excellence, Demetria Frank. I really want to make sure we thank and properly celebrate Professor Frank and her work and the culmination of her 10 years at Memphis Law in this chair of excellence and this symposium where we are happy to share all of the great work that she has done with the rest of the national legal education community. Professor Frank joined our law school in 2013. She was a colleague at first, but when I became dean, she agreed to serve as director of our Office of Diversity and Inclusion. In that role, she has fully transformed our law school. She's been pushing and inspiring me ever since. Her vision has always been vast, and I have done my best to keep up financially and otherwise in supporting that vision. But in that role, she has always helped our law school to stretch and grow. In 2021, I was finally able to elevate her position to Associate Dean for Diversity and Inclusion to match the effort and importance that she has brought to this role. And although I am heartbroken for myself and our law school by her impending departure, it was, I hope I'm making you cry over there, Dimitri. It was only fitting to honor her with this capstone title and opportunity. So as Herff Chair of Excellence, Professor Frank is not only able to host this national conversation, but she has the time and support to reflect on the tremendous growth she has led at Memphis Law, to analyze the data that she has collected, and to share that beyond our walls so that other law schools can learn from and emulate her work. I am tremendously grateful for Professor Frank's decades-long investment in our law school, and I am honored to know her as a colleague and friend. So with that, I will turn it back to her to kick things off.
Okay, I had no idea that you were going to do that. And thank you for completely putting me off my game as we start this panel. But I appreciate your words. They're too kind. I have a few disclosures to make before we begin. First is that we do not have all the answers. We could have had an entire symposium on any one of the topics we are taking up on the 3 panels today. We would love for everyone to leave with resources and insights that make our conversations around Standard 303C more rich, productive, and thoughtful. And that's the purpose of today. Just a few things, technical things, the chat feature. We want to make our time together today as engaging and interactive as possible. So periodically, we will initiate a poll or allow use of the chat feature to engage with you. However, your questions to each of our panelists, we've decided on each of our panels to hold our questions until the end. So if you have a question that you would like our panelists to address, please use the Q&A feature throughout. And for any questions that aren't answered naturally in the discussion, we will get to as many of those as we can toward the end of the discussion. And then finally, the biographies of our panelists and digital programs can be found in a link I am about to put into the chat now. I also want to make sure that we maximize our time today, especially since we are online. So we won't be providing a full introduction of all of our panelists today. They may elaborate a little more on their credentials, but that is not because we don't have a weighty slate of panelists. And quite frankly, if I talked about all their accolades, we could do a symposium on that alone too. So I do want to thank my panelists for allowing me to annoy them over the past few months about bios, topics, photographs, and the like. And also a special thanks to my graduate assistant, Penelope Brooks, who is helping today and who did a lot of the research on teaching cultural competence leading up today. So thank you so much. So let's begin.
I'm first, correct?
Yeah, let me get to a little bit of a context for everyone. Our first panel. So our first panel, we are dedicated to exploring how law programs plan to comply with ABA Standard 303C. We will also discuss how to set 303 outcomes and objectives, and our panelists will also offer suggestions on how to assess lawyer cultural competence proficiency. I am joined by Professor Anastasia Bowles, Dean Brant Lee, Professor Phyllis Tate, and Dean McMurdy Chubb, and we'll just get started. One of the questions in registration was about the current roles of our attendees, and so I thought it might be interesting to just take a look at who is in the room before we get started in the Zoom room, so to speak, and just so we know who's here. And as you can see, we've got lots of tenured faculty, a few untenured, a good number of clinical faculty will join us today, legal writing faculty, got lots of administrators. And in that other category, we had lots of practicing attorneys, people who are in higher education. I had people identify that. So I thought it would be interesting to just kind of get a feel for who's interested in this topic. And I think it's important to acknowledge what most of us have in common, regardless of our role, is this shared responsibility and interest to help our institutions get this right. And we are certainly have a collective responsibility to set norms and standards that promote our students taking education in racism, bias, and cultural competence seriously. So I'm going to start off by handing it over to Professor Tate, who will talk to us a little bit about what the requirement is, what 303C is, and what it tells law faculties and law schools and law faculty to do. And I'm going to get that for you.
Thank you. Good morning, and thank you for attending this important presentation. I'm going to provide a little bit of a framework for Standard 303C through the who, what, when, where, and how analysis. Of course, the who, what, and the where are specifically spelled out to us, as we're required to educate our law students on bias, cross-cultural competency, and racism. The when is also spelled out for us. It tells us at the beginning and before they graduate. So at the start of our legal program and at least once again before graduation. Now in the interpretation, we get a little bit more guidance on the how, and that's what our panel is going to focus on. The how includes options such as orientation for incoming students, lectures on these topics, courses incorporating the topics, and other educational experiences incorporating these topics, and that includes our experiential options. Now, this provides, I think, a lot of flexibility, but to satisfy the requirements, law schools must demonstrate that all law students are required to participate in a substantial activity designed to reinforce the skill of cultural competency and their obligation as future lawyers to work to eliminate racism in the legal profession. Now, it is important that law schools take this mandate seriously, especially as seriously as Memphis has taken it, if we wish to produce culturally competent attorneys who understand bias and how it may influence their own actions and the actions of others in the legal community. Only then will they have the skills to adequately represent a diverse population and reduce bias and racism in the legal profession. Now, before we continue, my co-panelist, Professor Bowles, is going to provide some key definitions.
Good morning. I am Anastasia Bowles. I am a professor at UA Little Rock, William H. Bowen School of Law, and I am also co-director and co-founder of Bowen's new Center for Racial Justice and Criminal Justice Reform. I just wanted to say thank you to Professor Frank and Dean Shofton for putting this together. Demetria had already planned to say this. You have been a tireless servant of the Memphis law community. You have stood with the city as it reckons with the death of Tyree Nichols. You always add such an inspirational and insightful perspective. And so I wanted to join the chorus of those who love and support you. As Professor Tate was saying in the introduction to the standard for 303C, there's a requirement, but not necessarily guidance as to the content of what's required. And so we thought we would just start a conversation about some definitions. We didn't attempt to define racism because of the many definitions, but bias, this is kind of agreed upon. I took it from Merriam-Webster, but this is throughout the literature, an unreasoned, unfair judgment or preference. And so we can generally think of racism as that bias in action. So racial bias plus action, right, results in racism. So I will leave it there generally, given what I think we want to encourage law schools to do, which is really build out definitions for themselves. We won't have time to talk about every tool today, but we wanted to talk very quickly about what does cultural competence mean. And so I've put up a couple of paradigms that I use in my work. So we can think about cultural competence, cultural proficiency as this set of values, skills, principles, behaviors that can enable students and lawyers to self-assess their own culture, value the diversity in others and environments, manage the predictable cultural differences and conflicts effectively, be able to adapt to diversity, and then institutionalize the knowledge they have gained and be able to go through the cycle all over again. There are other models of cultural proficiency, and each school should focus on what resonates to them, their students, and their faculty. When we think of measuring the progress towards cultural proficiency, it is inherently difficult because we never arrive at cultural proficiency. It is a fluid, evolving journey. I use what's called the cultural proficiency continuum in my work. It's based on the work of Kikanzi Nerdy-Robbins, who applies the concept to K-12 and higher education. There are other models, so sociologist Milton Bennett, the DMIS models. So his stages are denial, defense, minimization, acceptance, adaptation, and integration. Neil Hamilton and Jeff Maleska have identified a synthesized model where students move from lack of awareness into recognition, conscious implementation, and proficiency. And so I say all this to again say that one of the first things that schools need to do is clarify what model and what kind of continuum works, and then design their program around that. So again, and I'm not going to go through each of these stages. I wanted to make the point that the stages on the first 3 points, destructiveness, intolerance, and blindness, really are reactive. So they tend to problematize cultural difference, make cultural difference deficient. We hear language around students being underperforming, right? And so difference there is problematized and othered. Whereas the next 3 points, where we want our students to move to, is cultural pre-competence, competence, and proficiency. These 3 points are proactive. They view cultures, other cultures, as underserved instead of underperforming, right? It is a more inclusive model that seeks to not only bring other cultures into the fold, but support their voice in doing so. All right, the last thing I want to say is just drill down a bit on pre-competence, competence, and proficiency. So I think pre-competence is where a lot of institutions find themselves. So culture is conscious, but differences are engaged superficially or inappropriately. So, you know, a Women's History Month celebration or a Black History dinner. So we need to make sure, as we're thinking of implementing 303C, that we're not staying at pre-competence and that we're not encouraging students to, you know, do one thing in their entire year and stamp themselves competent. We really want to move students and ourselves to the level where we're using the tools of cultural proficiency continuously. We're committing to constant change. You know, we're open to growth. So with that, I will hand it over.
So I'll invite other panelists to comment on anything else we want to know on a general level about 303C before we kind of delve into the rest of the conversation. Is there anything? All right. Well, we'll dig into our next question, which is, why don't we just take some time describing some of the things your schools have considered in meeting the 303 standard? What kind of ideas have gotten the most support? And I would love for you all to talk about this from both an institutional level, but also if you've had any internal conversation about this and what this means for your courses, invite those comments too. I will ask Professor Dean Lee to start that, and maybe we can pivot back to you, Professor Bowles, once.
Sure. Thank you so much for hosting this and for inviting me. Actually, I want to make 3 kinds of comments. One of them is about the process. One of them is sort of laying out a list, and then I'm going to talk about a particular different kind of thing that we did at the University of Akron. So on the process, I just want to start by saying, you know, just observing that this standard was not adopted unanimously, right? There were objections. those objections were based in things that are going to be objected to when we lay out the program as well, right? So just in the background. Secondly, I mean, I suspect we have done what a lot of schools will do in a situation like this, which is bring together an ad hoc committee, right, to come up with a recommendation for the faculty to adopt. And at our school, the ad hoc committee included some faculty members. Just as an aside, the usual suspects who always take on a little bit of additional work when there's diversity issues, right? So I'm sure all the people in this panel. And also some administrators, right, which I want to talk about that a little bit as we go through. With regard to what the options are that we are still considering, I want to start by noting that the standard is not very high, right? We might have broader goals than the standard because Professor Bowles is talking about students attaining cultural competence. The standard just says provide education, right? And minimal at that. But that is, you know, if your institution just wants to make sure they meet the standard, it's not actual competence, it is just some education in it. And then the one item I just want to mention it in order to set aside is, although I think we might come back to it, the standards is about students, right? It's not about faculty. Although when you talk about what the options are to deliver that education to students, right, the competence of the faculty to do that is going to be part of that discussion. So, you know, really just quickly on the different options, I'm just going to lay out a few things on the spectrum, and other people can fill in other ideas. You know, you could just have a one-off speaker, right, as your one pre-graduation event. All you have to do is make sure that all the students, right, did it. You could have a menu of events, right, pre-approved that students could select from, right? And if you do that, you can require as many hours as you think is necessary, right, to do that. You can make it one event, you can make it 6 hours total throughout, you know, before you graduate, and that kind of thing. If you do that, you can work with other organizations who provide programs on this, right? We talked to the local bar association and the state bar association who are developing programs like that. Most of them are online, right? And so you can figure out a way to work with them to administer that kind of thing. Ideally, right, you would provide this education throughout the curriculum in each of the courses in law school because they're relevant to all of that, and I'll just leave that there. And then there could be a required course that everybody has to take at some point before graduation, right? And so I mean, so that's kind of the spectrum, and we can talk a little bit about strengths and weaknesses. And the one thing I'll say is the administrators need a way to check things off, right? And so if you give them a list, and you know, some of them you can't pick things that there's no way to tell, right, whether they did it or not. Well, I guess you could just have them attest that they did, and if that would work for you. The one thing I wanted to mention about what we did that actually combines possibly satisfying part of this requirement with some community education, right? Which is that in the, you know, at the end of the summer of 2020, right, the summer of Black Lives Matter and George Floyd, our dean asked me if I would teach a free online course to the public about race and law. And I agreed to do that. I kind of have been wanting to do that. 14 weeks, 1 hour a week. And we were shocked and surprised. There was so much community hunger for this kind of education. We had over 5,000 people enroll from all over the country. One of the things I'm doing right now is trying to turn that into an asynchronous thing that we could simultaneously offer for free to the public, but with just a little bit of asynchronous assignment right, could offer to our students as a one credit course, that would be one of the ways that you could fulfill the standard. So just laying out some options and highlighting one thing that we did. What I have.
I also want to note that the interpretations of 303 itself offer some suggestions. And Dean Lee, thank you for throwing out so many different variables of what I'm sure many of us have been discussing. But don't forget that there are some things there that are suggested that would satisfy. And I would urge schools, as they're having these conversations, to really think of this as probably a floor, not a ceiling, because the amount of seriousness we give these topics as administrators and faculty, our students' understanding of it and seriousness they give to it will reflect that. And so, although the interpretation is instructive, I think, as Dean Lee alluded to, there are lots of other opportunities and places we can be creative here. And I'll invite Professor Bowles to also tell us a little bit about what you all have been doing at Arkansas Little Rock.
Sure, just briefly, because I think we as well are really, in this, and at UA Little Rock at Bowen, it's our curriculum committee that is taking a look at this. So several of our clinics do this already, and there's a component of our externship course that has as a module on lawyering across differences. And so I think the clinicians are getting together and making sure that that second part, that the experiential clinic part, that they can bolster that and meet the standard. We do have a 1L course called Professionalism in the Work of Lawyers, and it's a 1-unit course in both. It spans the semester, but it spans the year, but it's 1 unit, and it has evolved to take on a lot of different aspects of professionalism, professional identity, wellness. And so that would also be a place that we can put in some cultural competency, some material for the standard. One thing that in my discussions with our curriculum folks, that they really emphasize that this has been an opportunity to look at the curriculum across the board and see ways to pull in throughout the whole program of legal education. So as Professor Frank says, we're not just meeting, but exceeding the standard. And on that note, the faculties recently approved a social justice concentration, which allows students to take courses in racial justice if they choose. They do a writing project. They do their policy and procedure requirement. We've approved co-curricular credit for our court observation program that I'll talk about in a little bit. So there's a lot of ways, like Brent was saying, that we can get creative and connect the first year all throughout to the second part contemplated by 303.
And I'll invite everyone else, if there are some things you talked about at your school that seem interesting or that have gotten some support, I'll invite everyone else to offer some insight.
Yeah, I just wanted to say thank you, first of all, Demetria, for hosting this event and for having us here today. And it's good to see so many people from across the country, friends and colleagues. So I wanted to say first, just like Dean Lee, I had several areas to kind of offer some comments. The first is that 303C is actually probably the first time that through our accreditation standards or otherwise legal education has been invited to critique itself. And I think that, that is problematic on so many levels that, at the, where we're now in 2023, and now there's a reckoning in legal education when we've had the same curriculum since 1879, like literally, right? So that's problematic. But understanding too that our curriculum comes from a particular position, it has a positionality, and that positionality, our curriculum comes out of the Gilded Age and into the Industrial Revolution to protect to protect capitalism, right? So if you look at our curriculum, that is what it is. So we're in this position, this tension of having to try to integrate cultural competency or DEI into a curriculum that is at its core hostile to that very notion. So I just want to point out that that's a tension there that we're feeling. And then secondly, I wanted to talk, just very kind of really, and vulnerably here, that I think at many schools, discussions about this, is frustrating because you have people who have been doing the work and who want to move forward, people who don't want to move at all, and our students are really pushing us. So as Dean Lee said, the standard is about students, but faculty have to be incentivized to both embrace the standard and teach it, but also be educated not to inflict harm in implementing it in whatever ways law schools choose. So that's an issue as well. And so I will say, briefly, because the question is about like, what are we doing? Our school has had discussions about this way before 303, and we're quite frankly just stalled as to what to do. I think they had settled on, at some point a one-off course at some point, but then, there was the tensions about, we're going to be preaching to the choir, like who's going to take this course? Not going to be required, right? And so I was invited, our DEI committee was having a discussion about this, and I was invited to come and talk about what I thought should happen. And I basically said, I think we need to integrate DEI into the entire curriculum. Like we don't need a one-off course. So I wrote, after, George Floyd, the summer of our reckoning, and, we're in an urban law school and felt viscerally all that was happening around us, and just the helicopters flying overhead and all of this, and what the reaction was. Our chancellor actually declared that we were moving toward becoming an anti-racist law school. So this made like a university effort. There were grants to create inclusive teaching modules. Our Center for the Advancement of Teaching Excellence now has an inclusive teaching certificate to educate faculty. And I wrote the 1L Anti-Racist Curriculum Project, which is 11 videos and 8 teachers' manuals that are designed to retrofit the curriculum. And the videos are like less than 15 minutes. And we did not get, even though the students wanted this, the faculty gave me the go-ahead to write it, we did not get broad adoption of this video, right? Because people were just not ready to implement this. They weren't ready to think about it, to talk about it. So, I just want to throw that out there that, there are discussions, they're stalled at certain points. I think the takeaway here is you have to keep talking and keep moving forward. I mean, eventually what happened this year is that we just did an orientation session for our incoming students, right? That was it. And we also have a critical race and gender studies concentration that I direct, that has been overwhelmingly like high enrolled since 2020, right? I think we went live actually in 2020. So, that's a way that students are getting what they need from us. But I want to also emphasize what many of the panelists have said, that this is a floor and not a ceiling, and that, we want to exceed, not just meet the expectations, and that our students are ready, even if we're not.
An excellent point on where students are versus faculty. Students seem to be coming in expecting it, and considering the events of the last several years, students are coming to law school because they want to have those conversations oftentimes. So I'm wondering, just quickly, what kind of awareness you believe your students at your institutions have about 303C? Do they know it's coming? What kind of awareness do you believe students have about it?
Well, I can tell you that coincidentally this week, I actually had a a question to my students because we were in property class, and I'll talk more about integration. Terry brought it up a few seconds ago, but I'll talk more about the integration into your courses in a second. But one of the things that we were talking about this week was the BP chemical case, where they were drilling underground and it was spilling over into some of the neighboring neighboring homes, I'm sorry. And we had, of course, this is the opportune time to talk about environmental racism. And so I had a video for them, and then I had a couple of slides where we talked about the expansion of that already discussion we were having. And so somewhere in there, I asked, how many of you are aware of environmental racism? And less than half of the class was even aware. And that wasn't even the minority students. They were even unaware. So it's not just that you come in with some kind of baseline because you've lived through this. And some of the discussion about what they thought about it was a little bit disheartening, because it was, if that's what they can afford to live, then that's the consequence of being able to afford to live there. And so talking to them, talking through that with them, and trying to navigate them through the hostility that they clearly have towards the topic. And on the other side, recognizing that these are people and these are companies taking advantage of the poor. It sort of moved it a little bit, but it was surprising to me the number of students who were just completely unaware of environmental racism at all.
Absolutely. So I want to initiate a poll to our attendees real quick as we transition into talking about how do we actually do this for those of us that are contemplating doing this in our courses. Maybe we've done it before and we want to do more. Maybe we're doing it for the first time. I want to get a sense from our audience, and not applicable is there for people who aren't currently law teaching, but the question on the table is, have you included education on cultural competence, racism, or bias in your courses? And then the second question is, do you plan to include? So have you, and do you plan to? And can you all see them? You all can see it? I wonder if my attendees can, because no one's taking it. So let's see. Okay, there we go. And this is anonymous. So make sure you click submit. All right, so I'm going to end the poll. There's still people on. I'm going to share the results there. So it looks like about 69% of our attendees have. That's the majority of the people who I guess would be teaching. About 17% not applicable. And then we got 14% who said no. And then that number moves up. Do we plan to 82%? So I guess that gives us a sense that we do have some people here who haven't incorporated racism, bias, or cultural competence in their classes before and plan to. And so with that backdrop, I will invite my panelists to now talk a little bit about if we are considering supporting the standard by including teaching on these topics in our courses. What advice do you all have?
I guess I'll start, since I promised to come back to this in a few minutes. I teach, just so people can get an understanding of where this comes from. I teach income tax, estate and gift tax, tax courses, as well as wills, trusts, and estates and property on a rotating basis, depending on the year, not all at once. And I have included this type of teaching, gosh, for as long as I can remember, probably started within my first year of teaching. Now, I will tell you that that is a difficult thing to do. It took me a while to figure out where my, where the spot was in each of the courses, because it's not the same in each of the courses. So for instance, in tax, which is actually where I started teaching it more deliberately, and the other courses a little bit more passively, and then they became deliberate. So one of the ways in which I figured out you have to do it is to integrate, not supplement. Because in tax, what I started doing was supplementing. So I would give them what I called enrichment projects. And so they would work on these together. They would go and, seek out this information that I gave them. And I was so excited about what they were going to come back with. And then I came back and it was very little participation. And later I figured out, by giving them the enrichment project, they took that as optional and they just opted not to do it. And so maybe they didn't see as important because maybe I didn't treat it as important. I thought I was going to get buy-in just by giving it, and I'm the professor. But that didn't work. And so I had to figure out a way to integrate it into the courses as where it naturally fit in, because you can't just start talking about it either, because if you just start talking about it and lecturing about it, they disengage and they're not part of the discussion. So I had to figure out where it made sense. I had to figure out, course books where they gave me natural fits and natural cases that would give me the option to have the discussion, so it didn't seem like busy work or extra work. And in tax, it may not be easy, but it's accessible. So for instance, when we're talking about the mortgage interest deduction, in tax world, you don't collect race data when you're preparing your taxes. You don't see that there. And so one of the ways in which I was able to integrate that was when we're talking about the mortgage interest deduction, we talk about, the requirements, what you do to qualify. And then we talk about, this is the way I snuck it in, how much it costs the government annually to support that. And once we got into the billions of dollars a year, and when we started out, it was billions of dollars a year. And I'm talking like 80 billion, 90 billion, $100 billion a year to support that. And then we go over into, who qualifies for this. And that means that somebody has to be itemizing their deductions. And so what income level are you at to be itemizing your deduction? What level does your house have to be at to generate that kind of interest? And so once we started that way, we're talking from a socioeconomic status. All right. And so then we get to other topics such as the same way, sale of a principal residence. This is still housing, where you get the first $250,000 of appreciation on your home tax free. So we talk about, what you do to qualify. And then we talk about who probably qualifies, because now you got to talk about neighborhoods where homes appreciate, right? And so once we did that, then we do the rates of home ownership, and then we do it by race. So that was a strategic but backdoor way of bringing in the conversation, because it wasn't directly in the book. If it's not in the book and they don't read it, they don't want to do it. So that's why you have to find a way to integrate it into what you're already doing in the course. So that was tax. And there are some other ways to do it. I don't do it every single class, but I do it in places where it makes sense, so that by the end of the course, they have some level of proficiency. Well, not proficiency, exposure. Let me use the right word. All right. And then for instance, in property, I just gave you an example a few minutes ago about the BP Chemicals case and environmental racism. Another place where I introduce it is we have a Mintosh case where the Native Americans had tried to sell some land that they owned. And the government basically said, we own it, you don't, so we have the right to sell it, you don't. And one of the ways in which I explored the bias in that case was looking at the language that the court actually used when describing the folks. And it was like savages. They're unable to take care of themselves. If we don't basically conquer them, they're going to be, savages and come back and fight over the land. So we got to do these things basically to protect them and protect ourselves. But they use that kind of language in the case. And so we actually explore the language that's used in the case and how the judge might have felt about the plaintiffs in that case. And so that's another way in which you can get to both culture and race and ethnicity all in one case, because they gave you that information. And with wills and trusts, in that class, we talk about it through the heirs property and talk about, who that primarily inhibits and affects, how that leads to one of the leading causes of Black land loss. And then we talk about, some of the ways in which, the structure of intestacy is done, that is the worst kind of way to transfer property. It primarily affects poor folks, and the leniency that we see in trust land, and how they facilitate transfer of property. So I don't believe I'm the only one in law school who has courses that have the opportunity to integrate this. So I think that we can all do this. It's just that you have to, take baby steps, because the first time I tried it, of course, it didn't work out the way I thought. The second time I tried it, it didn't work out the way I thought, but I didn't quit. I kept trying to figure out various ways that it was going to work. And I had to figure out which ways it worked in each of the courses, where it made sense. And so that it didn't feel forced and it didn't feel like some kind of extra work or supplemental work for the students.
And I want to continue to beat the drum about both intentionality and integration. And so remember, I was talking about the 1L anti-curriculum project and what wasn't, how we needed the step before the step. So this is the step before the step. I wrote a book called Strategies and Techniques for Integrating Diversity, Equity, and Inclusion into the Core Law Curriculum. This book is free for download, and you can also request a print copy from the publisher. And again, it is free. And so my approach is holistic in the sense that it kind of memorializes the things that Phyllis was just talking about. It's like about, intentional course planning. So we start at the level of your learning outcomes. So, there are learning outcomes that are, you have to ask yourself, what is my learning goal for this course? Or, and then you look at, okay, what is my comfort level with implementing DEI in my course? And so I have learning outcomes that range from, beginning all the way up to advanced that you can pick from to choose. So this is just an example of one. Deconstructs how race, class, gender, and sexuality influence how lawyers and courts frame legal issues. And then from that, you want to figure out what kinds of learning activities throughout your course will support your DEI goal. And so for this particular learning outcome, these are performance criteria from which I can construct activities in my course. And these will also form assessment criteria later on. So in chapters 8 through 14 of this book, I go through every single course in the core law curriculum and the 1L curriculum and provide basically lesson plans and examples. And again, as Phyllis was saying, those natural places where you can integrate additional resources. So not really a heavy lift for your faculty. And again, I won't spend a lot of time on this. I do whole day-long workshops on this. So I won't belabor the point, but I just want to give you a sense of, what's possible. So I'll show you also an example of let's see here, a lesson plan. So this is from the book. This is a sample DEI assignment plan for a civil procedure. As you can see, it was, this is what was on that slide. So here are the skill levels intermediate. Here are my resources that I'm going to be using for this particular activity. And again, you will notice that this is really intentional. So I can't, do this on the fly. Like I have to have some thought about how I want to plan out my course and what I'm going to use. And this is really important. So then there's a description here about what the assignment is. Then I go into, this is the assignment title. These are the directions for students. And all of this, again, is from the learning outcomes and the performance criteria and our assessment rubric for this particular assignment to demonstrate for you, how do you prepare to do this? How will you assess it? And again, the more it can be part of your class, the better. And students won't think it's a one-off thing, and they will engage with it. And, intentionality is extremely important. One of the things that I always say is when professors do DEI on the fly, things go awry. So you have to plan, execute, reflect, and improve. Plan, execute, reflect, and improve. And so again, if you're interested, download the book, call me. I do workshops for faculty, have been doing them for many, many years, but specifically on this topic, and usually come, in the summer or at the break in between semesters, so that people can be thinking about their syllabi and what they want to, put in their courses and how they might plan them. And, I tell faculty as well, I'll say this last thing, that if at your school, not everybody wants to do this, you can find your people, right? Find 2 or 3 other people who want to do it, and you all can, debrief about it bi-weekly, talk about what's working, what's not working, and be a support for each other. And so I think that that's important.
Thank you, Terry. I really want to take a moment to highlight some of the resources that are out there, because just like everything else with being a law professor, there's some self-teaching involved with this if we're going to integrate this into our courses. And I did put Dean McMurdy's book in the chat, so you can get it from that site. I also want to highlight, last year we did a faculty teaching cultural competence series where we invited faculty from other schools to come and teach our faculty about integrating cultural competence in their courses. And as Dean McMurdy noted, she does workshops like that. Thank you last year for Professor Bowles for participating in that. And I also want to highlight a resource for those of you considering a full-on course, because there's not a lot of materials yet that are addressing students specifically. And one of the speakers, or a couple of the speakers in our series last year, was Kimberly O'Leary and Mabel Martin Scott, who authored the book Multicultural Lawyering. Thank you and shout out if either of you are in the attendee list today. But there are just a lot of different ways to do this. And so we do hope that we can share our resources with you all. And in a moment, I'm going to put in the chat a little bit of a bibliography for our conversations today. So moving on into one of our final questions for this panel, let's talk about outcomes. We started the panel, and I think one theme I've heard from everyone is that we really have to be intentional, and we have to take this seriously if we're going to be effective in providing this kind of education to our students. So we have to talk about outcomes, and Dean McMurdy got into it just a little bit just now, but I want to invite others to talk about how you all, and you also, again, Dean McMurdy, to talk about how do we set outcomes? It's such a new area for many of us, and there's not a lot of literature on setting outcomes out there. There's some developing, but that seems to be need to be a part of this conversation. So I'd invite our panelists to talk a little bit about setting outcomes in this area. And Professor Bowles, I know you all did some efforts to identify outcomes.
Yeah, I'd like to defer to my co-panelists because we had a little bit of mistakes that I want to discuss. So I'd like the ideal to proceed before my discussion.
If there is an ideal, I don't know if we're going to get that out of this panel, but certainly.
When the planning, I mean, you look at the literature on teaching and learning, and so you can figure out, how learning outcomes need to proceed the difficulty level for them. There's a ton of literature out there, and a lot of it, on your current faculty, the same people who worked on learning outcomes for the ABA standards when we had to do learning outcomes are some of those same people who might need to be in the room when you're thinking about learning outcomes for DEI integration into your curriculum. But I think also there's a step before the step, right? So that's if your faculty wants to do integration, they may not. And so if not, then you need learning outcomes for whatever activities you're going to be planning. So I provide a ton of them in the book, both at the course level and the classroom level, but you might need to create learning outcomes for, let's say, if you're doing an orientation session and an exit session, or like all of the various ways that Dean Lee talked about, you can begin to implement 303C. So, I mean, the key takeaway is thinking about, again, being intentional and thinking about what kind of learning outcomes. And if you've ever been in a room when you're developing learning outcomes, you know that it is a contentious and fraught process. There's not going to be consensus. It's going to require a ton of conversations. I remember the last time I was engaged in that process with faculty, it took over 3 years to like settle on learning outcomes. So don't think this is just going to be like a really quick thing, right? Because it's not. If you're thinking about integration, it's easier, you know, maybe easier, I'm going to put the caveat in there, maybe, to get your arms around it if you're doing like, you know, an orientation session or something like that, and working with the student life people and that kind of thing, but much more difficult with curriculum committees and things like that. But again, think about what your end goals are, and I think you can, you know, work back from there.
I think one of the ways that we can actually, I'm sorry, go ahead, Dean Lee. I go next.
Okay, I just wanted to chime in and say, you know, all of those things that Professor McMurray-Chubb said, you know, really important to do the outcomes. It is possible, easily, to do a lot of these things without thoughtful learning outcomes and just, you know, have them done. And if your faculty or the committee is mostly concerned about having a plan to satisfy the standard with them doing the least amount of work, which is, I'm just going to say, right, is going to happen at some schools. It's hard to get very far into this planning process without realizing that you need them, right? If you're going to have a list of things that students can do, what's your criteria for what counts, right? And if and it's, you know, you could do that kind of, oh, well, this kind of sounds like diversity, and put it on the list. But if you really want it to make it meaningful, then you have to have at least some discussion. And when you get to that part, and, you know, one of the reasons why it's hard when it goes through the curriculum committee is because everybody's going to vote, right? And so this is really going to depend on the local environment, right? You know, we have a faculty member who very, very concerned about what might be taught in critical race theory, and that would be horrible, right? I'm sure we're not the only ones, right? So it's not as though this is gonna just fly through because, you know, you thought of some really great things to have as learning outcomes.
And I just wanted to say, to support the faculty in getting this done, I think our deans need to be supportive in that, in bringing in consultants. You got some right here on this panel, and probably throughout this whole symposium. So bringing in people to help facilitate conversations between faculty members before we even get started, I think is very helpful, because people are going to come in with their own definitions, with their own biases, and what they think how it's going to hurt. You're going to have someone who think how it's going to help. And I think having those conversations before you start the conversations, like Terry was talking about earlier, is critical to the process. And that requires dean support, because that means, you know, paying somebody to come in to do this work to help the faculty help themselves, so that you'll have maybe a little less resistance if it's not as awful as they think it's going to be, because they're thinking about that extreme version of somebody coming in with a raised fist and all of these things. And it really doesn't have to be that aggressive and to be effective. And so getting that support from your deans, I think, is a very critical step before the step, as she said, that we have to engage in. That might hurt, that might prevent some of the pitfalls that Professor Bowles is about to tell us about?
So I'll tell you about two pitfalls that we have, that I'm taking full responsibility, and I have written several articles on this. The focus of my research is on delivering culturally proficient legal instruction. So, us as professors being culturally proficient, and I made these mistakes. So I'm going to publicly own them. And so a couple things to bring into this that I want to reinforce first. Number one, the standard does say that you can do an other educational program, right? And so I want to encourage you to think broadly about what types of programs you can do for your 1Ls that might really deepen the learning environment. Number two, 303B also talks about the development of professional identity, which is a new requirement. And so a lot of this goes together. And so there's a lot of opportunity to, kill two birds with one stone, or really integrate a sustained program. So we recently, I said that I recently helped co-found, and I now co-direct the Center for Criminal Justice and for Racial Justice and Criminal Justice Reform. And we received approval in July 2021. And we have two missions. Number one, academic research about racial justice, but number two, professional development of students who come in and really want to do racial justice work, right? But then kind of get bogged down in the curriculum. And we have a host of programs. I won't go through them. Focused on police reform and pipelining and community partnerships and courts. But the one I want to talk about today is our court observation Arkansas project. We call it CORE. We got a $1 million grant from the Walmart Foundation to do a 3-year in-court data collection process. So I will say that the first year, we just, for those of you who do empirical work, this will sound, hilarious to you, that we didn't think we had to go through IRB approval. So like, if that helps tell you where we were. Which is the Institutional Review Board for those who haven't done empirical work, where your institution has to review and bless your research. We thought this was kind of a public observational study. We were just going to skate through. No. So the first year, we are trying to meet our goals under this grant, and we're just engaging with judges, trying to design the survey. I'm trying to learn Qualtrics, getting our IRB application, setting up a pilot project. We're meeting with students for 2 to 3 hours a week, decompressing, talking through the tiers, right? We're doing all of this stuff. And I was not thinking at all about learning outcomes. I was assuming that this experience was, the exact type of experience that would satisfy all of our goals. And so let me see if I can you see my screen? And so kind of at the end of last year, I wanted to put together just a backwards looking assessment, just to see where we were. Like, I just wanted some feedback. And I found that the knowledge outcomes were really easy. We're used to delivering content as professors. So, all of the criminal procedure at the state level, like, they were great on that. We had trained them extensively on empirical research methods. So all of those, I kind of was very intentional about that going in. Well, my attempt to kind of throw, it's not, okay. All right, so my attempt to throw cultural competence at the end, like, let me just put it on the list. We gave them a whole list of, knowledge, skills, and values that come up in the literature. And we were just looking for feedback. And I threw in culturally competent lawyering, with no explanation, right? Because it was just the list, expecting it to be 100%. These are among students that are highly motivated and highly inclined for racial justice. They're very interested, right? They came and walked with us through this year and could not connect, many of them, right, to the idea of culturally competent lawyering. So we backed up again. And this year we've been able to focus more on training, right? And building out the just training for the projects and thinking to the curriculum that we want to develop. So we built on those assessment, those evaluation categories. We took off cultural competence because we wanted to see, what were the values that were actually coming up. And 100% of our students said these were the things that they're getting most out of the project. Understanding themselves, understanding people of other racial backgrounds, learning effectively on their own, developing a personal code of values, and a sense of professionalism. So that goes to that identity foundation. To be honest, that is not what I thought they would say. I thought that they were going to focus externally because they're in an observational study, but that is not what they did. And so now what I am doing is trying to map the things that students felt were impactful, because this is the stuff, the knowledge goals part of cultural competency is really, honestly, it's not hard to teach. Like Dean Lee says, if you just want to pop it up, here's the paradigm, here's the presentation, but the values and traits, which is where we want to take this, are very hard. And so if you have a program, and our program, where students are saying, this was transformative to me without you really trying, then at that moment, look to what your learning outcomes are. And this is where we're going to supplement with some intentional curriculum. All right. And so they're saying this is teaching them how, if we go back to that list of the goals of cultural proficiency, this is teaching them how to self-assess culture, to value diversity, to start to manage conflicts. There's been a lot of conflicts. And so now I'm going back and thinking, this is not really, I was really honestly thinking more about the institutionalization, the memorialization. I'm thinking data, right? They said that they are starting at this deep level, 100% racially diverse group of students. So this is an elective program. We do pay our students. We're offering a co-curricular credit, but we are experimenting now with how we can bring 1Ls who have really wanted to do the program, and how to create a space, because 1Ls, their schedule, they can't go to court repeatedly. I know other law schools do this. Toro has a great model. But how can we pair that professional identity and that kind of exposure to courts with what we know students are going to inherently get out of it? How can we scaffold that experience? And maybe that can be what Dean Lee thought when he said, another experience other than a court. This was just scratching the surface. I think as I go through their evaluations, I can mine all sorts of things that I'm not thinking of with my professor brain. And our students are telling us the things that are impactful and the things that they are motivated by and interested in, and we should really listen to them. So they should be engaged in designing content that meets this standard. Again, these exposure and experiential programs are so important, and the standard does contemplate the second part being part of an experiential learning or clinic. I really want us to think about bringing that to the first year, because there is something about, for example, court observation, going to court, seeing how this really happens. We are in district courts. These are low-level traffic offenses, misdemeanors, right? It is a different world down there, and they, just get blown away. So also not on the survey yet, I'll stop here, is wellness and trauma. That's an important part of professional identity and of cultural competence, because we were also not quite prepared to support our students for the secondary trauma. So we have fixed that through some, staff training and being very explicit about, like, this is what's going on. You're not just really tired. Like, this is, it may be happening. So I just want to encourage you to use other experiences, bring it into the 1L class when you can. We're expanding our model. And even if you did make a mistake and just, it didn't land where you thought, that you can, keep trying, because our students want this. So, I hope I didn't go too long.
No, and they need it. And that's the reality too. And I've always balanced it against, do I want to deal with the uncomfortableness now myself as an instructor, or do I want this to be ignored while students are with us, and then they learn the uncomfortable lessons in practice? And so that alone, I feel, I've always felt a responsibility. I do want to have some time for questions. We started this panel a few minutes behind, but I want to keep us as on track as we can be for the day. And I think that your last comment, Professor Bowles, goes at one of the questions that came up in the Q&A. And you all, I'm sure, can see it yourself, but the first one was directed toward Professor Tate, but I think all of us could probably speak to how it went the first time we tried to integrate CRIT or cultural competence lessons in our courses. And so that question was directed to you, Professor Tate, but the secondary question here is, did it have a negative impact on your teaching evals? And so I'll invite Professor Tate, but also others who may have some experience.
All right, so my first attempt, it did show up on the eval, but it showed up as we were giving busy work. We were giving too much busy work and not enough content for the course. Of course, that's not true, but that's how they interpreted it. And so what I took from that is, so the evaluation itself, I still had high scores, but that was one of the comments. And so what I took from that is, I got to find a way to make sure that this is more inclusive. And so as the years going on, because I've done this for probably over 15 years now, those comments disappeared over time. Towards the end, before I left FAMU, which is where I started it, they were gone all completely, like no mention of that. It's almost like they were getting it and they just knew that was part of what we were supposed to be doing. And so, yes, in the beginning, but I think that was based on more of my clumsy attempts at getting it done. But once I was able to kind of fine tune it, it's almost disappeared. Now, so fast forward, I'm at a new institution, and of course I had to start over. And even though I've got the system down, of course, it's not received in the same way. So it is like starting all over again. And it was the same thing. We had too much other work. We were talking about too much other things that didn't relate to what we were doing in the class. And so even then I said, well, let me fine tune this in a way that is even less, I guess, less intrusive to them. So I started out the way I used to, which is, we're going to start with the inequalities, because everybody can relate to poverty. Everybody can relate to, the underdog. And from last year to this year, just making that fine-tuned adjustment, the evaluations got better. That didn't come up. So still got the high scores, but those comments is where you're looking for trends. And even though it wasn't a trend, it was, one or two, I still took it seriously, because I want everybody to feel like they can discuss and have open conversations in the course. So, so yes and no to that answer.
I want want to inject a point here about teaching eval, and it also relates to faculty of color tending to take on the heavy lifting when it comes to this kind of education. If we leave it to our faculty of color solely to take on this heavy lifting, given that trend on teaching evaluation, we are also putting the heavy lifting of negative evaluations on faculty of color. So I don't want to miss that point that kind of underlie what you said there. And I'll continue to invite other panelists to respond on this issue of how this goes the first time.
I will jump in on 2 points. One of them is, especially in the current environment, I mean, I've done a lot of adjusting over the years. I present in a very calm way. You're going to get negative. You're going to get people saying, you know, not everything's about race, or, you know, whatever the context is. And that's just what it is. That's what this subject will bring in some ways. Of course, you minimize as much as you can. But I was also just going to highlight the fact that, you know, when you have outcomes that are, and I've had some of these in my seminars, like, you know, did you gain a deeper understanding of your own relationship to racial inequality, right? The assessment looks different, right, than it does for lots of other kinds of learning outcomes. And just, I mean, there's work out there that you can reference, and there's ways to do it, absolutely. But if you're not used to, you know, getting your assessing your learning outcomes that way, it does look different. You can ask directly, but you know, it makes a little bit less sense sometimes.
So
And I would say, you know, oh, sorry, Demetria. 3 things. One, you know, when Professor Bowles and Dean Lee were speaking, I was thinking about, you know, you if you're to the extent you're connected to a bigger university, there's a deeper bench that you can draw on. If you have a teaching and learning center or a center for the advancement of teaching excellence like we do, these are people who all day long think about teaching and learning, right? So they can provide you with resources. You don't have to reinvent the wheel. They will come in and do workshops for your unit, you know, offer tons of resources. They are there to help you. And so that's one thing. The other thing is, I think, if you think about universal design and learning and making sure where everyone can have a point at which they can access your course, and also thinking about the importance of community building when you're talking about difficult topics. And I think that's important as well. So we don't put emphasis on community building, setting community standards, but I think that's really important when you begin to talk about issues around difference. And you will see a change in your students and their relation to each other and their relationship to you, and the amount of grace that they will give each other and to you if you put some time in there. And then the last thing I wanted to talk about was, I think it just like flew out of my head. But yeah, I'll remember. But go on, Demetria, with what you were saying.
Can I just add a really quick point? I give credit for it. So all of these discussions that we have in class, when we bring it in, students are going to view it as, you know, just random and superfluous. But 20% of my final exams, which works out to between 10 and 16% of the total course grade, is what I call the policy essay. And it can be directed, it can be open where I let them do it, but they then engage in these kind of vigorous gender and race and class and, you know, all of these debates with each other, because they're viewing this as, this is my chance to bring my life experience and my perspective into the final. And so if you think it's important, you have to give them course credit for it. It can't just be enrichment, you know, like I think Professor Tate said enrichment, like if you code it like that, that's how they will take it. So I start and say, this is the type of discussion that will help you with your policy essay. And if I do not let an open one and I assign one and they didn't get to, do the one that they've been debating with their classmates. They will come for me afterwards. They're like, you didn't let us talk about, whatever it is. So they've been very invested in it.
I remember what I wanted to say. So I wanted to also say, to piggyback on what others have said about understanding trauma, but not only trauma-informed lawyering, trauma-informed teaching, and racial trauma that our students are coming into the room with, that we are coming into the room with, the tools that we've, developed for dealing with them and assessing the level of health with those tools. I often talk about tools that minoritized people use to navigate interlocking systems of oppression as being tools out of survival, not tools out of being like the intentionality of being taught like how to navigate these things to keep our well-being intact. So that's important as well. I talk about that a lot in the book and some strategies, and also about majoritized and minoritized identity development. So I think understanding, Janet Helms, as a sociologist, has a lovely paradigm for understanding white identity development and pushback about when things are taught in the classroom. So I think understanding where our students are coming from, anticipating conflict. I'm always amazed when people think that they're going to do this and there's not going to be conflict. Having a strategy for how to work through it. You will get pushback. There will be conflict that you have to manage, anticipating that, and having some tools developing and getting those tools to deal with that conflict are very important. But also, we don't want to increase our students' trauma. We don't want to increase our own trauma. And so for administrators, it's also understanding what you're asking your faculty to do when you ask them to do this, and that everybody is coming to the table with a different status, a different rank, a different standpoint, a different position, and that it's going to cost us all different things to do this in the classroom. And what are those supports that you're going to put in place to make sure that people aren't negatively harmed? So back to what Demetria was saying about teaching evaluations, and my role as the Dean for Faculty Development and Research, I make sure that those people who are evaluating junior faculty have the literature on teaching evaluations, right? And developing workshops for them about like, what does this look like? Looking at the literature on how do you assess like anti-racist reading strategies for scholarship, so that they're not implicitly dinging people who write about minoritized populations, right? So all these things, like you have to think widely about what supports and policies you're going to put in place to facilitate implementation of 303C and beyond.
Thank you, Terry. So I think that to round this out, we'll go to another question in the Q&A. And I think it's a really good question, and I don't know that our panelists will have the answers because it's kind of a question for the ABA, but I would love to hear your comments on it. And the question is, how much can we trust the ABA to review compliance? And is the ABA aware of its own need to do better in terms of cultural competence, equity, and diversity? And I think that's a great question. It also is a good transition question to our next panel addressing obstacles.
Yeah, I'll jump in because I'm a law professor. I don't know anything about it, but I'll talk about it. So in the ordinary way, of course, the ABA, like lots of mainstream institutions, are going to have blind spots on this and not. But I do want to say, and this goes back to the student evaluation thing too, you're going to get some critiques. But now, with the advent of more and more sort of, well, I guess woke has become a pejorative, but woke white people, right? You also are going to get a lot of support. From in your evaluations, right? From students saying this was the best thing, I've ever seen. This spoke to me in a way that I've never heard before. And I think that the reason I'm raising that with respect to this question is that is true in society generally, right? The ABA is also hearing from lots of members who are on that side of the ledger, right? So their blindness might be, you still have to deal with that. But it's gonna at least be balanced in some ways by the current generalized movement towards racial equity. Right?
And I looked at the standard as a great first step to where we need to go. And I think it is a first step, and it's going to get more and more, more requirements as they get more comfortable with what is required. And I think what they're going to look at is how the law schools respond, which is why we got so much flexibility in how we implement this. And I think they're going to be looking to us as law schools for guidance about what it is that we're going to put as the next natural next step. And I took that as the same way that I did when I first started getting into this. The first time, I didn't get it right. I tried something, that I thought was, a minimum standard, which is the enrichment project. It didn't work, but it gave me the tools to get to the place where I am. And I think that's how I'm looking at how they approach this in far as giving us, a wide parameters. Now, what we as law schools, I think, can do is inform them about what we need to do next. And maybe that's what they're waiting for, because they tell us that we can integrate into the course, but they didn't tell us how much of the course percentage would qualify as integration. I think that's something that we're probably going to have to come up with and figure out. And once they figure out how the schools handle that, then that's what's going to come the new floor for that. How do we assess faculty successes on this? Are we doing these through the annual reviews, or are we doing some other measure? I think we have to figure that out and kind of inform them, because I think they know that they're operating a little bit blind too.
Thank you, Professor Tate. And I would like to thank all of our panelists for this first session. We are off to a great start. I do want to encourage those of us that did not happen to register for today's symposium to do register. It probably seems pointless now, but we will be providing a bibliography for the entire symposium to those that we have your email. And the way we get your email is through registration. So thank you so much to our panelists. We're a few minutes behind. If you all could give us 5 minutes to switch out our panelists, we will be right back. Thank you so much.
Good afternoon, everyone. I want to give our panel a second to get settled, but I did want to offer greetings and thank you all for joining us. I know there's challenging weather across the country, so I hope everyone is safe and warm wherever you are. But we will start in another minute or so. And I'll turn things over to Dean Frank.
It looks like we have all of our panelists now. I just want to kind of set it up, and then I'm going to turn it back over to Dean Henderson. This panel will be moderated by Siobhan Henderson. She's the Associate Dean for Diversity, Equity, and Inclusion and Belonging, and a lecturer at the University of Texas at Austin. This panel will discuss the challenges to implementing Standard 303C, including the divisive concept bills, aka the attack on critical race theory, diversity in the legal academy, political climate, and COVID-19. Without further ado, I will remove myself from this panel and put it in the trusting hands of Dean Henderson.
Perfect. Thank you so much. And I want to just start with a few opening points here. As in my capacity, I do a myriad of things, and I know several people on this panel also. And so we will be approaching the content from our varied perspectives. And as we talk through these things, I hope that you will think about some questions that might be useful for you in identifying challenges and weaving through some opportunities in our discussion is essentially what we're going to try to do over the next hour and yielding the final 20 minutes for questions and answers. But as you all know, law structures relationships, it structures and governs behavior. So we're thinking about how we sustain, how we elevate, and demonstrate the principles that undergird 303C as a standard. And as the first panel described, talking a little bit more expansively about it, I think is helpful. And with that, I'm going to share a screen in hopes that we can maybe find an entry point to level set how we are thinking about 303C as an opportunity, of course, with the challenges that we know exist with it. And in context for this first question to the panel, since we will be expected to provide much of this training, even though many of us have been doing this prior to this call under the standard, starting with some framing around COVID-19 and its role in moving the conversation on equity forward. I think that's a helpful entry point for thinking about strategies and maybe ways in which you have already adopted a lens for this. And so I would like to invite Vice Provost Contreras to speak to that from a university perspective and maybe offer both how those challenges really solidified the way in which we could think more expansively about our standard.
Thank you, Siobhan. So I'll just briefly introduce myself. I am Lydia Contreras. I am a professor here in chemical engineering, and I think my role in this panel relates more to looking at this from the institutional level, as I also serve here as the Vice Provost of Diversity, Equity, and Inclusion for faculty. So one of the things that we have noticed after that I think it's a direct result of the pandemic is the faculty really examining a lot about how they want to teach their courses. So they are really doing a lot of work thinking about what are best practices, how can I make my classroom more equitable, and what were opportunities that worked the things that I did differently during the pandemic. How did I offer, for example, conversations and office hours outside of the norm that enable my working students to take advantage of what we were doing? So I think the flexibility that we have seen works to the favor of making changes in education. And I also think that the willingness to finally say, which is, I think, a big deviation in our culture as academics, is to say, look, I may not have known all along how to serve the best of my students. I need to reach out to the rest of the community, to the rest of our campus, take advantages, even with people outside of our campus in other universities, and start these conversations. What are other people doing? I think we were also desperate about finding solutions and surviving these changes that created that willingness to finally accept that we don't know all that works, and that we can learn from others. And I think those are two things that are going to be huge as we also shift to new initiatives in education.
Thank you for that. I think that's an important shift in how we think about education as a product, how we engage with our students as they navigate their very real lived experiences. And I want to invite the others that are participating in this panel. I think you had some unique perspectives. Dean O'Brien, I'll begin with you, since you came into this interim role of yours post the pandemic, but you've seen the shift.
Absolutely. So I look at my tenure in legal education as pre-COVID and post-COVID. So I didn't see how sausage was made in the interim. And so what I have seen is a shift in how content is delivered, how flexible we are now in how we deliver content. So for example, this ice storm that we've been experiencing, your lecture and your course virtually. I'm uncertain as to how many professors took advantage of that, but I do know that they developed a muscle in how to revamp their approach to delivering content. And so with developing that muscle, it's a muscle they can take into this conversation. Also, I've seen from the university, something that I do not recall seeing in my initial tenure, is inviting faculty, staff, and deans to receive training and certification on how to address students in crisis. So I know COVID raised a lot of mental health concerns. And so now being more aware of the mental health and wellness aspects of our students, and inviting faculty, deans, and staff beyond your usual mental health support to be engaged and supportive in that regard and understanding. So that's my take, is just observing what has changed since my pre-COVID tenure with the University of Memphis Law School and my post-COVID tenure.
And I think to that, another feature of that is how we think about our students in the classrooms, their lived experiences, expanding modalities, and providing good opportunities for entry there. Would others like to introduce how they navigated those changes?
Well, Dean Henderson, I'll speak up on that. I know, I will be honest. So one of the hats that I wear is I'm an adjunct professor at the University of Memphis Law School teaching fair employment practices. And quite honestly, the pandemic initially kind of threw me off, because we were instructed maybe 2 weeks before class was supposed to start that the classes would need to be virtual, a couple of years ago. But like the panel has already discussed, what it kind of forced at least me to do was to exercise the muscle in flexibility and be agile, not with the content of the subject matter, but how I delivered it and how I could best serve the students, which I think is a skill that we will have to employ with implementing 303C. But I mean, when it came to best, serving the students, we had to be flexible on a virtual office hours, whether that be, day or night during, I'm an adjunct professor, so I have a quote unquote day job, but, had to be flexible throughout the day to be of service to them, because we weren't in a classroom setting where after class, there's a barrage of people coming up afterwards, because a lot of times they didn't feel as comfortable doing that virtually. So you just had to be nimble. And if we're talking about equity, one of the things, though, in the virtual setting that I understand or have an appreciation for a lot better is the socioeconomic disparity. Because what I didn't quite appreciate from one student to the next was the difference in access to technology, Wi-Fi access, and even their individual residential, living experiences. Some of the students, did not have a space that was quiet or free from distraction, so you had to recognize that, appreciate that, and be flexible enough to try to deal with that. So, I mean, if we're talking about, okay, cultural competency, having a better understanding of the experiences that students are going through, COVID-19 forced me to address that and appreciate that.
That's very helpful. Matthew, you have any additional points there?
I do. I joined the UT faculty a year and a half ago. So I came in August 21 when everybody was in most red states were forced to be back in person. And I had a 3-month-old son at the time. Of course, masking in a lot of places was very politicized, including in Texas and in this building. And so I was immediately faced with both sort of the politics of being in a room with people who were choosing not to do that. And then a couple of things jumped out at me immediately, even though I've only been at Texas for a year and a half. Before I went to law school, I was a high school teacher for 6 years. And so I had a ton of strategies on engaging students and all those sorts of things. And I got in the classroom and I noticed that all of the studies about participation and what we know about male versus female participation, white students versus students of color, and those sort of disparities, that seemed to be magnified in an environment where people were wearing masks, or there was sort of this weird, I had students over here without masks and the students with masks were sitting together. And so it did force me immediately to think about engagement and modalities and being able to be an effective instructor and trying to reach people, as many people in the classroom as possible, engage them. And I'll talk about those strategies, I think, a little later in the panel. But it was really stark because I started the job and a week into class realized the boat was sort of already going over the waterfall. And so I had to scramble and really be creative in the ways that I engage students and integrated content into the course.
No,
And
and
if I
go
can
ahead.
add something to that, that last comment really made me think about how much of a struggle was really to implement equity. I think we throw the word equity out there, but especially when thinking of classes, I mean, students demand equal treatment, not necessarily equity. So for you to take advantage or for you to really address all those needs of all the different students in the room, we almost had to take the approach of blankets that covered everybody and did the same treatment so that, right, it really covered everyone wherever they were. We couldn't do necessarily one approach for one student or one for another student or one for another student, even though that was what's clearly needed. So navigating that world of equity versus equality and meeting everybody's needs was sort of something that seemed fair for everybody was really a challenge. So I think that's another thing that we can borrow a lot from when we're trying to implement new ideas and curriculum. It's thinking of ways that we can cover everybody, reach everybody, no matter where they are, right? Knowing that the competencies are going to be different, the needs are going to be different, but it's really difficult in a classroom to say, this group, because we know your situation, you can turn in assignments 3 days later, but not anybody else, right? And so it's thinking about how we do that. I think when we have such a disparate group, either intellectually, in skill sets, in what, they understand their competencies, their resources, it's really a challenge that we face, I think, seriously for the first time.
Yeah, no, and I think to all of your points, COVID-19, the pandemic, and how we had to become nimble and accelerate and propel how we navigated those challenges for many across our institutions at the highest levels and through ranks of faculty, through administrators. For us, in thinking through law and the lives of individuals, the people that we work with, or more readily 303C and 303B as a companion part, I try not to separate the two. We're making visible legal issues. We're making visible lawyers and communities that were often invisible. But how we then think about how we work with students to integrate those skills and competencies as professionals in a professional terminally degree program, I think is important. So encapsulating COVID-19 as a starting point, as a launching pad for us to do this work might be helpful for various folks who are participating in the panel. You've been doing this in some ways, and so we are just going to refine it and think about it through the lens of 303C a bit differently. And I think that takes us into the next question I would like to pose to you all for consideration. It's both an external and an internal challenge. Legislation in states, of course, is looking at, how are we instructing, how are we training, how are we hiring around these ideals or principles of equity and inclusion, and how does that exist in tension, if at all, in tension with 303C? Well, what we know is that 15 states have passed a range of bills. 7 of those do target education and instruction. And public law schools, private law schools will have to navigate these challenges differently. And so I would like to, just start with you all and weighing in on describing both the challenge that legislation may pose for you in your individual roles, but how you navigate that. And since we ended with Vice Provost Contreras, maybe we can start with you in terms of the institutional level lens, thinking about that with respect to faculty development and also support across rank of faculty.
Yeah, I think this is a really important point. So I think in the panel earlier, we heard either a panelist, there was some discussion about how making sure this work doesn't fall on the same types of people. So there's a couple things we can do as an institution. We can go out there and start recruiting and hiring people with a strong DEI component and expanding the set of faculty that can really engage, participate, develop this curriculum. And we know that we're going to have to be really creative and really think deep as to what is it that we want. Because in a lot of our states, just saying merely enough, we want a certain demographic, it's not something we can do. It's probably not something, it's debatable whether or not we should do. So what we really want are people that are willing to engage with this topics, that have the skill sets that can engage with these topics. So thinking about how we expand when we're thinking of hiring criteria now in based of these requirements, so that there's not the view that this is this set of faculty that can teach this and the rest can teach the rest of the courses, right? But really incorporating that into the fabric of a competency that everybody can teach is going to really be important for several reasons. In the panel before, the idea of stigmatizing evaluations in classroom and student evaluations came up, but it's also a lot of emotional work and labor that this work can have. And it can have a lot of work when it comes to, relieving trauma, et cetera. So I think spreading the work and finding the support to do that, it's going to be critical. And I think that comes in hiring. I think that comes in support, resources, finances, staff, so that faculty don't really have this as a completely extra load in their work that they have when it comes to implementing this curriculum changes. And I think also realizing that this may cost a deviation in how students see faculty and interact with faculty and in their course evaluations, et cetera. So when we're also putting in especially our earlier career faculty there, or professional track faculty that don't have sort of that job security in the university, it's going to be really important to think about how top down we really support these roles and really communicate that this is not the agenda of this one faculty member. There's not a political agenda. This is a requirement and something that the whole unit sees as important. So I think at multiple levels, that level of support, and it's going to be really important in communication, that it's institutionalized and not a single faculty out there, especially in states like ours, where that kind of work can be really politicized.
That's very helpful. And I think to follow up on that, are there particular recruitment and retention strategies that you might suggest or offer to navigate that challenge, unique opportunities that those who might be serving in positions who have an institutional support structure for law schools specifically, or all CSUs? What are there ways in which folks like you who might be participating can engage with this work differently on retention and recruitment?
Well, when it comes to recruitment, I think one of the things I'm pretty proud that we have been doing here at UT Austin, it's really emphasizing the role of mentoring. It's really emphasizing the role of engaging in community issues and skill sets in issues of diversity and equity. And so that's a new way that we have been emphasizing that this work is important to everyone, and that we really value that in an applicant. We can't require it, but we can make the statements that we value it. So I think that's something that from the top down, I've been really proud of what we're doing. I also think we have been putting a lot more emphasis in deans, for example, auditing the level of service that all the faculty is doing. A lot of this work also, yes, it shows up nicely in a course or in a module when it's brought up to the public, but a lot of it requires a lot of work that's hidden and not recognized. So that's another way that we're trying to make this work, and the faculty members doing it valuable, as well as also providing seed grants, where we negotiate with deans and we negotiate where they get some teaching relief to make new curriculum, and they get money from the provost office to hire grad students and collaborate with undergrads and researchers that can help them put these kind of curriculum together, which could be a lesson in itself for students working in it, and a good collaborative mode where the faculty member, it's also training and mentoring and working in a sense of community rather than alone, but it also is a support, literally support to do this work. So in the terms of TAing, resources, consultants that they can actually go and pay for, we're trying to provide funds for that as well.
That's very helpful, and it might be some ideas in that for others that are participating. I would like to draw in other panelists on this as well. And Dean O'Brien, I know you've got some particular experiences as an administrator navigating this work, both from the perspective of how do you generate buy-in? Can you generate buy-in and good faith participation? And what does that challenge look like when you're navigating the broader landscape of legislation that otherwise might seem to be in tension with some of your work?
Thank you, Siobhan. So in Tennessee, as some of you may know, Tennessee is one of the states with the divisive concepts law. However, thankfully, I guess we could say there is a carve-out accreditation standard. But even with that carve-out, buy-in may still be a challenge for faculty as well as students. And I think it's important to call out the student aspect as well in implementing, integrating this content. So when I think about faculty, one of the things I've heard just in discussions, because I've asked faculty, from other law schools, what are your concerns or challenges, even when you do have this carve out? And there seems to be a fear factor. Some faculty may feel for lack of training, even lived experience or resources, that they're ill-equipped to have these conversations, to integrate these concepts into their classrooms and lectures. And so they may fear cancel culture being tarred and feathered professionally, or they also may fear causing harm to the students. I even recall in my own law school experience where a well-meaning professor attempted to have a conversation that blindsided the students, and it did not land well, and it wasn't effective. And of course, the goal is to be effective. So one of the solutions there, and I think we've talked about it a bit, and deans can support in this regard, is to provide faculty with education on the topics, as well as training and resources on how to integrate the topics. And I know we talked about that, and there are resources that were shared in the previous panel, but it'll be helpful to help them navigate these conversations in the classroom to address the fears they may have. Some resources were previously shared in the chat, but there's a Stanford Clearinghouse on DEI research, and also the University of Buffalo School of Law provides some resources and materials on experiential learning, and also from faculty and clinicians on how to address some of these concerns. As it relates to students, as I mentioned earlier, students play a role in how effectively faculty can implement these concepts. They play a role as it relates to student participation. And so there's a challenge there for students. They may choose not to participate for fear of their own, fear of what you call a career limiting move, or fear of being harmed in the process. Also, lack of diversity as well as lack of inclusion may be a factor in the effectiveness of implementing 303C in the classroom. And so, one, to address, the fear, I would say definitely setting expectations around engagement are important. You want to create a culture of commitment and safety where they can share and learn, and also an environment of trust between the students and the faculty, as well as what I would have recommended from my own experience in law school is to not blindside the students. You want to include, whether it's in the syllabus or in your opening discussions, that there will be thoughtful discussions of race and bias and cultural competency throughout the semester, and also share with them the what's in it for me, the benefits, as well as the goals, to really support that student buy-in. And of course, I'm the interim assistant dean of diversity and inclusion, so I do want to highlight the role that diversity plays in the classroom for student buy-in. I was one of 3 Black law students in my own law school class, so I remember those experiences where topics were raised, but there wasn't the diversity of background or thought in the classroom to carry the conversation forward, or to provide any sort of insights or alternative perspectives. So the expectation of robust discourse from the faculty member was not met. So even though they had a carefully crafted syllabus, they prepared their lecture, they even brought their own experiences, it fell flat because of the lack of diversity in the classroom. And so one of the ways to address that is to partner with your Office of Admissions, partner with your deans of diversity, equity, and inclusion as you recruit, but also as you holistically review law student applications, looking for that diversity of background, looking for that diversity of perspective and viewpoint to support the buy-in and participation and robust discussion within the classroom. And lastly, I'll speak to lack of inclusion. I think it's important to be inclusive of topics relevant to those underrepresented and marginalized populations within the classroom. And so I recall, again, first year property, I can't remember the case, but there was a case where I really wished that there was a Native American student in the classroom that could have provided insight. But then also, if the faculty member doesn't address that perspective, it doesn't really give that Native American student an opportunity to weigh in. So you want to be inclusive of the topics you cover, so that those students feel an opportunity to be included in the discussion, as well as engaged in the learning.
No, that's very helpful, and I think it scaffolds and really supports Panel A's discussion of the role of intentionality and integration of topic. But beyond that, I think what it does support is the role of D&I officers or associate deans, and ways in which collaboration and really moving this work and thinking about the project of this work as collaborative and not necessarily siloed work is important. One, to share the load, and also to mitigate some of the unintended consequences. And I do want to think about this, and before we move on to the next question, like the really interesting interplay of writing faculty and collaboration there as an option, and strategies there. Matthew, could you speak to that a little bit, and how you've done it in navigating student difference, as well as ways in which you can, as a separate cohort of faculty members, work to support the larger project of 303C?
Absolutely. And in talking about that, I think at the top, it's important to recognize that the data on course evaluations is incredibly clear as far as identity politics and what professors get higher evals and what professors get lower evals just as a default. And I think that it's another reason why people who look like me, it's critical for us to be involved in this for all the reasons identified, because if I'm, as a white male, getting a natural bump in course evaluations, and there's fear that some students are going to punish professors, then it's important for professors like me to be involved. I'm fortunate in that I think that LRW is a perfect vehicle for doing these sorts of things, because I'm teaching, how to do research and how to analyze problems, but I need dozens of examples on how to do that. And so I'll do sort of a big example and a small example in my first year legal writing course. In fact, I'm teaching this class on Tuesday. We're going to talk about framing facts. And one of my colleagues came up with an exercise where she took 6 descriptions of criminal immigrants from Supreme Court cases, and it's just the description of the defendant themselves. And the descriptions vary from, here is 5 paragraphs of this wonderful human being who had, a couple of minor indiscretions 20 years ago and is a productive member of society, to a 2-sentence description, this person is a career criminal, they should be deported today because they're a danger to the United States. I use that in class, and there's 6, like I said, there's 6 of them. And so I have the students read them, and they have to guess which sitting justice wrote that, and they have to guess, is this description from an opinion that supports the state deporting this person, or in favor of the criminal defendant who's an immigrant. The trick is that the 6 are actually pairs, and they don't find that out until they've done all that work. And so then they juxtapose this 5-paragraph description of this, full human being versus, a short Alito summary of, this is a criminal, get him out of the United States. And what it does is, it is, to the first panel talking about integration, I'm able to integrate that curriculum into my curriculum in a way that is 100% germane to the lesson, which is framing and talking about legal ideas and facts and those sorts of things. And the initial sort of lesson is, look at the different ways that you can describe these things and how those are instrumental towards getting your outcome. On the back end, then I'm able to say, why does this Alito 2-sentence summary of this person, why is he able to do this? Well, because that person is both an immigrant and a criminal defendant, people who are marginalized. And then I can have a short discussion about marginalization and bias and different cultural experiences. And so what I do in my LRW course is I look for small opportunities like that. What am I teaching that day? What are the examples that I can use and integrate? On the bigger scale, we also, and I think this is what Dean Henderson was getting at, is we have, like most legal writing programs, we use teaching assistants. And so the 8 of us here who teach first-year legal research and writing, each of us has 3 assistants, and the LLM program has their own teaching assistants who are 2Ls or 3Ls who did good in the legal writing course. And we were evaluating, they take a fall class that all of us sort of tag team teach. And we were evaluating that class and realized that they were receiving no sort of instruction on how to interact with students. So they weren't receiving any bias instruction or how to conduct office hours, or how to think about students. And so I saw that not as to Dean Henderson's point, not as a challenge, but as an opportunity to step in and teach that. And so instead of integrating that sort of into another lesson, we just created a bias training, and here's how to approach difficult problems. There's 8 different scenarios in that course. The reading lessons were taken, the articles were taken straight out of critical pedagogy stuff. And so we're teaching our teaching assistants how to make sure that they're providing equal service and access to all their students, but they are also law students. So we're teaching them, directly teaching them bias training and racism training and those sorts of things, not in the purpose of teaching those, but for the purpose of teaching them to be better students and then to go on and be better attorneys. Because in that class, we also talk about things like being a competent attorney and what happens if you're a defense attorney, you have a bias against a particular group of people, and a witness comes along that can help your case, and you just dismiss that person because you have bias. And so it's tying these things back to both life lessons, competency lessons, but then also integrating them into the course. And you know, the great thing about teaching our teaching assistants those sorts of things is I worked with Dean Henderson. My other colleagues in my department were on board, and there was just a ton of buy-in and support all the way around in being able to teach all this content.
Before
Professor Reed.
before we move past, we were talking about it, and Dean O'Brien was talking about the fears associated with 303C and gave a pretty daunting list. I want to add a fear factor to that, and then Dean O'Brien ask you to speak on it. But it's, yes, in Tennessee, we are fortunate enough to have the carve out regarding accreditation standards, but funding could be affected. Public and private funding could be affected with the training and teaching of 303C. Do you have any thoughts on that?
Sure. So you broke up a little bit, but I heard the key word of funding. So I think I know where this conversation is going. So in Tennessee, I am fortunate to have a sizable DEI budget. However, also in Tennessee and various other states, there's definitely a challenge and attack on the DEI role as well as DEI funding and their efforts. So those funds, while available to me now, may not be available as much or at all in the future. Only, you know, time and politics will tell. However, you know, DEI budgets can serve as a supplement. I believe if your school is fortunate enough to have a budget and those funds available, it can serve as a supplement, but not support the lion's share, for example, faculty lines and things of that nature, because typically DEI budgets also manage pipeline programming, recruiting, and so forth. So you don't want to spread that one budget too thin. What I think you may be able to tap into is also, again, if the funds are there, partnering with admissions in their budget, partnering with student affairs in their budget as it relates to incorporating things like an orientation or programming and speakers and so forth. And I can expound even more on other external partners. You know, of course, you work with FedEx. So tapping into our corporate partners, tapping into our alumni, and even tapping into volunteers as well. So, you know, I could definitely think of a number of ways to provide funding to support in addition to or in lieu of DEI budgets.
That's very helpful. And, you know, and that I think that segues us into another part of how we can navigate part of this discussion, right? If 303C requires that, and as panel one discussed, we do this at the start of the legal education program and at least once again before graduation. Of course, contemplating that in some ways to be a part of experiential education, which not all law schools require or expect of students. So potentially navigating it as a standalone second opportunity for law students. It also, as we know, under the interpretations, does not prescribe for content and delivery. It does not offer up any form instructions, which poses unique challenges as well for administrators who are navigating this space, as well as faculty members across various ranks. And so I was wondering if you could continue that conversation, Dean O'Brien, and talk a little bit about those form and content parameters being expansive, but also ways in which they provide opportunities to provide additional engagement. Again, as the first panel described, there is some evaluation that may need to go into your individual institutions about what do you consider to be substantive exposure. And we can continue this in our working group sessions and talk about that on Saturday and other places for the symposium. But if you could start a little bit about some of the challenges that exist with form and content of delivery.
So when I look at the form and content, aspect, one, it's a matter of perspective. Either you think, well, you have to build it, or you get to build it. And so, of course, you have to build it because they didn't give you a required syllabus or, specific lecture content or exercises, assessments, reading lists. That wasn't provided by this. So there is, yes, you have to build it. And that could be a daunting process, working with faculty to determine what that content should be. But then you get to build it. Again, you get to decide how to build culturally competent lawyers, and you do it in a way that you find best suited for your law school and the legal profession. So you get to decide whether one else, prior to orientation, read a book on multicultural lawyering. You get to decide if they participate in unconscious bias training, or for us in Tennessee, if they engage in an experiential outing at the National Civil Rights Museum. And so there's definitely an opportunity, I think, that we shouldn't take for granted, that we have flexibility and creative license to some regard to make it a right fit for us. When I think about form and content, I think about it as a what, a how, and a who. And so, method of delivery, how do we want to go about that? Is it, I've heard someone describe it as kind of your low-hanging fruit. Hey, orientation. Well, the thing about orientation is, many law schools were already doing it. So it's just like, keep doing what you were doing. But, how do we want to do this? Is it orientation? Is it a lecture, the museum visit? Is it a required course, which may be a bit more challenging to create and hire faculty for an additional course or even fit it into the existing curriculum? But you do get to think through, how do we want to go about this? I think a solution, at least in talks with colleagues, is that some law schools are discussing curriculum mapping and even providing incentives to train on how to incorporate these concepts into existing courses. More challenging, but there are law schools who are looking at it. Who provides the education? I really support the collaborative approach. We're looking at faculty and deans, and again, alumni, external stakeholders, all partnering to sort of carry the load of the work. And so I'll speak, just from experience at Memphis, under Dean Frank, there's been a variety of experiences and symposiums and workshops and even unconscious bias training and visits to our National Civil Rights Museum to support these efforts already. Even in my prior role, I partnered with faculty in orientation to provide unconscious bias training and cultural competency training, even partnering with the local bar association and providing CLEs that were open to students. So I definitely think method of delivery and the who is a collaborative effort. And all of this, by not prescribing it, gives us so much opportunity to do what works for our students in our law school.
Yeah, no, I wholeheartedly agree. And I think there is that piece of intentionality behind how you do it, but you have a menu of opportunities and a wide range of ways in which you can introduce it. And I would like to invite others to speak to that point, from the experiential learning perspective, and the introduction of it there under Standard 303C, that as an opportunity, but in other ways, if there are other ways we might engage with this work and move and navigate through the challenges that it may or may not pose.
One of the things that came up when we were having our sort of before panel conversation that I thought was a really good point was engaging alumni. And it might have been you, Dean Henderson, who brought up that point, but I think it's really important when we're working with what, the who, the what in the class, the what to include, not to include, and in supporting the decision to take the higher road, right? Because this, as you said, Brian, this can be something that people say, we're already doing this. We don't have to really do anything extra or take absolutely the lowest bar just to check the box. But if we really think about it as a gap in the curriculum, that can be thought about much more deliberate and much more intentional to fill in the needs and the wants for students that are already going there. And our experience in a world post-2022, post-2021, and really engaging them in panels and discussions and ask the question, what can this opportunity really fill in for you that you have encountered starting your career as, in the law profession out there? Can we hear from you what your experience was like and what you hope something like this can accomplish? And maybe we really learn that this could be a lot more broader than we're even thinking, and we really collect some real life experiences to go back and get some buy-in from students, tell them reasons as to why this is fully relevant to them getting out there and really having the types of careers and aspirations and goals that they want. So really trying to come up with a way that we can have maybe an alumni advisory board of especially recent graduate alumni that have a lot of these experience and, a range of alumni, but definitely some that have experienced the world, the curriculum, and are now engaging with other colleagues that went to different types of programs, that did different things, and really compare and contrasting how we really sell this as an asset and make it an asset. Make it a real asset that really enriches the curriculum might be a better way to go around it than just some requirement that is contentions that we have to figure out how to fill in.
Yeah, no, I think to your point, the role of alumni, it's helpful. We sometimes lose them in our discussion of what we're implementing in law schools. And again, thinking more broadly about the project that 303C is, and under interpretation 303(7), what we know is that this can be delivered in a myriad of ways, going back to the prescribed content and form discussion. So we can use orientations, we can use lectures on these topics, but more discreetly, the role of alumni may be in how does it set what the business case is for this as a professional skill, and also how are they using it in how they engage with their clients and direct legal services, in kind of some of the cross discussion that might happen in law firms or corporate or private spaces around the needs of their corporate clients and the values that they may be setting. So building in this cross-cultural proficiency or competency, bias and racism education is a useful way to integrate them. And maybe, there's some strategies there in all parts of that, from orientation to lecture series.
Let me piggyback on that a little bit, and I'm gonna take my adjunct professor hat off and put my corporate counsel hat on. I really strongly suggest that during orientation or very early on, you do get your external partners, and that can be alumni, but it doesn't have to be alumni. But to really, if we're talking about buy-in, so yes, this is a mandate, but you also need students to buy in, and quite frankly, you will need a lot of faculty to buy in. And I think that the best way to do that is for your corporate counsel, your government employers, all of the employers to explain that in this environment in 2023, like we really demand that when we are hiring, we are looking for cultural competency when we're hiring attorneys or interns or selecting externs. I mean, we from a employer standpoint really need to early on make the case as to why this is important. It's not just a mandate, but it's important to us. We can start out with statistics. If we have, the DA's office, I'm just throwing that out there, or some of our attorney colleagues who are in law enforcement, if they can start out with statistics to evidence the need for this. We have Black people make up 13.4% of the US population, but they make up 47% of wrongful conviction exonerations, 35% of individuals executed by the death penalty, 22% of fatal police shootings. I mean, but we need to early on explain why this is necessary. Putting the mandate of 303C aside, even if that wasn't here, we still need this. We need to address the underrepresentation of minorities in the legal profession, and then make the case for DE&I within our organizations. I mean, there have been a lot of studies like McKinsey and Company, if you all are familiar with that, but they did an exhaustive research survey and can show a nexus between the diversity on executive teams and the profitability of particular companies. But we need to highlight that. It was the general counsel, if you all remember, about, 2019, I think, but 170 general counsel penned an open letter pushing law firms to increase their diversity. This is on people's radar, and it has been for years. So where, we in corporate counsel have pushed law firms, now law firms are beginning to push law schools, and it trickles down. But the most important thing I may be able to add to this conversation is from my corporate counsel role. This is being demanded now. And so law schools, if they're not already doing it, if they're going to service their students better, they need to step up and provide this training, because we are looking for it.
And I think it's supported by some of the interpretations. The importance of this goes back to, as the ABA views, some obligation that we have to promote a justice system that provides equal access and eliminates the presence of bias and discrimination in the operation of those systems. And I think necessarily so, going into some conversation about your role as corporate counsel and partnerships with institutions, and bringing back the discussion around funding. What some of the legislation that we are seeing in various states might do is limit that or prevent that in some ways. And so the question then becomes, in what ways can persons in these roles continue to be supported and provide the opportunities that navigate 303C uniquely, if they are operating somewhere where there may be limitations or presumed limitations on how to fund the work from an internal perspective if you're at a public institution. So Dean O'Brien and others, I would like to begin that as a starting conversation, the role of the additional stakeholders that are corporate counsels or private firms or outside stakeholders in supporting this work.
Sure, and I spoke to some of this earlier, but and one thing, if you take nothing away, I believe in collaboration and partnership, because it's going to take all of us internally and externally to do this work. And so I don't want to leave out the relationship that we should have with your development officers, because they've been building relationships within the community with alumni, with our corporate donors, and even community partners. And so externally, you want to tap into those relationships with development, even tap into the relationships the types of relationships the development has, but also the relationships that you have your own. And really, like Terrence said, make the case of why this matters to the profession. And also something that I failed to mention for faculty especially is pursuing grant funding. There's grant funding, available for this work. Unfortunately, I don't have a list to share with you, but one thing faculty is good at is research. So I know you guys will find the money out there. And then also volunteers. We think about that there's a cost to all of this. And for some things, there will be a cost for speakers, a cost for experiences. But there are those in the community who are equipped and passionate and willing to volunteer to support the cause as well. Again, tapping into your bar associations and bringing in, those alumni who are willing to come and help share the load and share the work. So of course, while thinking of funding in the form of, getting dollars, which we will definitely need, there are those things that are low cost, no cost. And so I didn't want to leave out volunteers as well.
There's another aspect to the whole funding thing that I think it's probably equally important, that is sort of less tangible. And that's the effect on morale that a lot of the cuts and the funding cuts and the program sort of monetary cost has on campus. So I just want to go back to that point of really forming community. This work cannot be done in silo. You really have to have your associate deans, your professors, and start thinking of ways in which you can make professor circles or discussion circles to bring people together. Or you can make networks of people across the university that are not just in the law school or the business school or the engineering school, but that are also associated with liberal arts, which traditionally has been a discipline very strong in creating these types of modules and handling this kind of landscape. So I just cannot emphasize enough how there is a huge emotional morale cost as well that comes when we're starting to see all these programs being targeted and cut, right? The funding, the money tells you a lot with where your ideas, your thoughts, and your priorities are. And when those funding comes cut, yes, the one thing is the money, but the other one is the other effect it has on the students, on the community, and it just makes the work a lot harder. And that needs to be really acknowledged. In addition to the extra labor, like you're already asking a faculty to teach a new module, to develop it, to engineer what the curriculum looks like, to also ask that faculty to go and seek money or resources external as almost as if this is sort of a stepchild course. It's really detrimental to the time, the energy, but also the emotional impact that it has on the morale of doing this work.
Yeah, I'm glad you raised that. In part, I know other large university systems like the University of Texas have created cross-community networks of diversity leads, in part for some of that community and morale support. We have one at Texas, and we meet monthly, both as a way to offer up shared ideas, even though we come from different backgrounds and disciplines. I think there are opportunities to create cross collaboration where resourcing may be limited. There are ways in which you can co-promote or elevate ideas and programs and utilize those in other departments. If you've got limited staffing or resourcing from an administrative perspective, and you're also relying on faculty, again, thinking about this as a holistic effort and not siloing DEIB as a separate add-on. A lot of law school spaces are very siloed in operation, but DEIB also often is infused in part of all of the things that we do and should be. And so it makes it laborious if we don't have some consideration for the morale effect, and then also how we can navigate that in a positive way for individuals working on these things. Did others have any points before we move on?
Yeah, I'll also, I think this is a great opportunity to talk about also collaborating with professors in other places. And for at least legal writing instructors, the Legal Writing Institute, LWI, is a phenomenal resource for this. They hold a conference every 2 years, but they have an online repository of tons of examples of both like the semester-long writing problems, individual lessons, and dozens of ways that all of these ideas can be integrated into, rule creation or fact framing or all the sort of little lessons that LRW professors teach. And so it is a matter of, it can feel, especially for a new instructor, it can feel completely overwhelming to tackle these things. And then you go to that conference or you look at those resources and there's dozens of things that are almost turnkey that you could take and integrate into your lesson immediately. And so, having those conversations both on campus and with finding like-minded professionals elsewhere, I think can be incredibly helpful in thinking about these things.
Thank you for that. And with that, I'll shift to our last kind of formal question before we open it up to question and answer. And this is an internal challenge that we face, but poses some unique, I think, opportunities. So as we navigate various structures, public, private, large university systems, smaller university systems, there is, of course, this concern about institutional awareness and how we all do this work, understanding the institutions in which we operate in. And so I would like to first bring in Vice Provost Contreras to talk a little bit about navigating institutions with additional structures of leadership, ways that can, additional ways. You've shared several in which a provost office may be supportive, but some of the broader context, we've got president's offices and leadership that matriculates through that space. But are there ways in which we should be thinking about navigating large institutions and institutional risk and risk assessment of the institution?
Yeah, I think that's a great point for this work to really have the impact and the leverage that we would like it to have. So, for example, for us to consider anything here, we have to understand that in our case, UT Austin is a large, decentralized public institution, right? So that means that the funding, there's substantial funding that comes from the state. That also means that sometimes what's happening in one CSUs or what's happening in one college or one unit of the university is completely not known or not even seen by other units of the university. So we tend to replicate a lot of the same work and work in isolation. And that also means that in that system, the deans have a lot of power to really get initiatives going and really move things ahead. So here it's very critical that the provost office works well with the deans, with their associate deans, and that we all have knowledge of what everybody's doing to really make work effective, consistent, deliver the same message, even when message gets delivered about anything that is at the institutional level. Some parts of the institution hear one message, by the time it gets to another one, it gets distorted. At the end of it, everybody's confused and people feel paralyzed because they don't know how to move forward. So I think it's really important to have clear lines of communications and expectations, clear people that are everywhere on campus, that you are consistently communicating and having a pulse on the community, because it's so large, you can really lose track as to where ideas, initiatives, and things are. And of course, being in a red state has its own challenges for this work. And I think this has already been brought up in the panel. It's not just faculty buy-in, it's also administrators buy-in, right? And the level of risk and risk-taking and risk adversity that each of these different units have across our campus in each position, it really, really depends on the individual, right? It depends on the risk that the president is willing to take, that the provost office can take, that the deans are willing to take, the faculty, et cetera. So really understanding the dynamics of how all that plays together and opening up an environment where there's honesty, there's a lot of openness, where these issues, concerns can be discussed, and people are, again, back to that flexibility that we've been learning over COVID, right? Being flexible to really ask the question, okay, well, maybe this is a strategy, but differentiating that strategy from the end goals. Can we all agree on an end goal? And the bar where that is might have to be different depending on where your people are, the institution really is, but at least agreeing on something that everybody can get behind And not so much on the way as to the how, that can be flexible, but where are we really going and what can we clearly communicate and how are we going to communicate this to make sure everybody's on the same page. So those are challenges that really affect our work in this area every day. When we think we got it, some other dean from another space in the university says, I'm not willing to do this. This is not something I can do. I cannot really mandate. I cannot really enforce this. I cannot even encourage it. It has to be up to the faculty for these different reasons. So, and that level of that threshold is very different across our campus.
Yeah. And I'd like to, you had a great framework for this and thinking about this from the college or school perspective. Matthew, if you could weigh in.
Yeah, I think from the school perspective, it's also important to think about have institutional awareness in the building. And so, I don't have sort of the concerns of a dean or a provost because I don't have those mandates. I am an LRW instructor. And so my primary concern is the content that I'm teaching my students. At the same time, it is incredibly important. I think one of the best ways that we can teach cultural competency and awareness about bias and racism is to model the behaviors that we want to see. And so it's important for me as an instructor to be aware of what's going on campus, to understand what's the makeup of the 1L class, what are the big affinity groups, what are the other activities that are going on campus, and it's just not to invoke Ted Lasso, but it's curiosity. I want to know what's going on because I think that makes me more aware of the students. And so, for example, when I was designing the bias training for our teaching assistants course for the LRW program, I had not even met Dean Henderson yet, and I knew that I needed to have a conversation with her about that. I also approached some other deans in the building and said, "Hey, we're doing this. Number one, do you have any input? But number two, from a to Provost Contreras's point, from a dean's perspective, do you have concerns about this? Do I need to be conscious of anything, any problems that are on your plate that I don't have to worry about as an instructor?" And it gets that sort of campus-wide buy-in, but it also lets me be more conscious and more involved, and ironically, it spins back to what we talked about at the beginning, which is these varied modalities and the idea that, I need to break the mold of I am standing at the front of a classroom delivering all these messages. And if I can do that by having a bunch of different ways that I address students through through office hours and other events and attend things that the students are doing that don't have anything to do with me and don't have anything to do with LRW, but they see me there and me involved, then I think that I'm modeling the behavior that I want to see in them and that I'm trying to instruct and teach them. And that sort of in the building awareness for people not at the dean or provost level, I think is incredibly important.
Well, thank you all for your comments. We've got about 10 more minutes, and so I want to raise some of the questions that we received. And first, one of the questions is what should schools be doing as a way to incentivize this work differently for professors to integrate cultural competency or proficiency in their curriculum? And then separately, as a part of that, are there additional ways in which we can navigate or think about the resistance of faculty members to including that as a part of their training? If we're thinking about this as a in the classroom substantive experience versus the additive ways in which we can approach this. Any thoughts on that?
I think to the incentivization of it, to incentivizing it, I think we have to understand holistically the workload of faculty. I think it's almost, this needs to be It's really easy when we think of new initiatives and new ideas that we want to implement. It's really easy to just think in a bubble of what this is and our goals. But I think when you really consider the fact that, I mean, academics are in general experiencing a burnout, especially a lot of the faculty that will jump up and want to do this work. I think thinking about how do you send a signal for prioritizing it by either compensating time with, resources and funds, but also teaching relief and balancing the workload so that this is something that somebody that's truly passionate and engaged can really do without feeling time exploited. It's going to be important when we think of sort of, backing out priorities. So I think that's one thought that I'm having on the question of incentivizing it. And I don't think a lot of people, I think in the earlier panel, there was the point made that you would get a lot of support. I think we're finding in a very encouraging way that many faculty in our university want to be inclusive, and they really want to do a lot of introspective thinking about how they're managing the classrooms and what are they teaching to the students and what kind of students are they ultimately sending out there that will be making big changes to our societies in the future. So I think there is more people that I meet that are really thinking about these issues than the ones that are not. So what we've decided to do in a lot of our work, it's really, there's some, when it comes to the faculty, that have a lot of resistance to a lot of new ideas and thinking about how we could be doing things that in a better way to include, be more inclusive. And we just kind of let them come along or meet them where they are, or really engage them in conversations where we hear more of the concerns and understand those perspectives. But it's going to be very important to know that this work cannot be politicized. We really have to treat it as a part of the curriculum, just like any other area and any other discipline that we think it's a tool. I mean, we heard in this panel somebody saying from a corporate perspective, this is a competency that we need from our people that we hire. So I think if we approach this in the same way as we approach statistics or data acquisition or interviewing people, I think we can be more sensitive to incentivizing the work. It cannot be traced or perceived or presented, I think, in my opinion, as a political topic where the goal is really to reunite everybody on a common view or vision of the world, because I think we're going to fight a lot more barriers that way.
No, that's helpful. And I think it's often helpful to have an engineer in a room full of lawyers and law professors and law deans, in part because like thinking about it as a process and systematizing it, we've got the vehicle of 303C that gives us some latitude with respect to that. And I pose this question to Dean O'Brien. Are there certain ways in which you're thinking about putting in monitoring or engaging? How do you track this? Part of the responsibility under the rules will be to ensure that students have had it twice, but it also suggests in other places that this should be an ongoing process. Are there ways or strategies or things you're thinking through in your role that might be helpful for those of us on today's symposium to know about tracking or monitoring this activity?
This question may be better suited for someone else on the panel, but I will say, it's the ways to track engagement, of course, knowing that orientation, if that's the approach you take, that's mandatory. You'll be able to track that participation. Whether or not you choose to have assessments to see the effectiveness of what they covered, that could be something else to monitor as well, as opposed to checking a box and saying we did it, but also understanding how effective it was and what the impact was on the law school climate and their experiences later on in experiential learning and externships and beyond. So there's opportunity to monitor and assess even there. Also, if it's built into the curriculum, then you're working with the registrar at that point to make sure that if it's a required course or just one of several menu options that they have, I hate to say, completed that requirement, And so that's one way to monitor as well. But I'll defer to other panelists as to ways that they may be looking at how to monitor compliance with 303C.
Yeah,
Well,
no,
I-
go ahead, Professor Reed.
Well, just real quickly, I agree with Dean O'Brien, and I'm gonna put on my other hat, being over FedEx's intern and extern program, but in particular, the extern program, because one of the ways to track and monitor this would be feedback from the field supervisors. Now, with that said, going back to the partnerships, one of the things that will need to be done is to loop in the externship experiential learning field supervisors, because I'm aware of this. I can assure you that most other field supervisors are not yet. So they'll need some education on, what the standards are, what the school is trying to accomplish. But in the evaluations that we have to fill out for the students who are placed with us, one way to track it could be within that evaluation form. Once we understand, all right, what is the goal for, the cultural competency, bias, and all that. But that's one way I think this could be monitored and tracked.
Perfect. And we have about 2 minutes, so I don't know if we have enough time to fully engage with this question. But if we're thinking about the role of tenured faculty and their support of this work, and also how they can support a holistic approach in sometimes a faculty-centric space. Are there ways deans should be thinking about navigating tenure track faculty in this D&I project? So the lion's share is not exclusively on administrators or persons that have dual hats. Are there interesting ways that out of the course of this conversation, you might have come up with a new idea? If not, it's thought homework, as a friend of mine would say, for all of us to think about. But I want to open up the floor for you all to, in the last minute, to maybe think on that question.
I'll jump in and piggyback on something that Provost Contreras was talking about, which is, that my LWI experience, again, is it's one thing to give overworked professors sort of any mandate, but the idea that you would go from, here's something that we're going to try to implement, here are 3 or 4 very, very specific concrete examples of how you could do this. So a contract professor could teach, contract formation instead of using the cases in the case book, use cases that you're also able to double dip, or same thing with torts or something else. And I think that, I hate to put work on other people because I don't do this training, but I think one way to get buy-in from faculty, from especially tenure faculty, while also addressing the burnout thing is to filter 303 somewhat in a way where we're making it concrete, we're giving turnkey examples, and making it easier for people to implement this and integrate this into their existing curriculum.
And with that, we'll close, and I'll hold some reminders about the first panel's discussion of metrics and assessments, and the work and labor that is, figuring that out at your own institutions. But I will now turn it over to Dean Frank.
Thank you so much, Dean Henderson. Before I let you go for a lunch break, and we will reconvene for our panel C, I want to initiate another poll to our attendees. And the question this time relates to challenges, since we just talked about challenges. And that is, what will be your biggest institutional challenge in implementing 303C? So I'm gonna end it, even though about half haven't participated, but I think this gives us at least a starting point to think about this. It's about 50 of us, and there's our answers. I would be curious as to the people who said other, if it's not anything exploitive, throwing that in the chat. I hope in part with this is that we create some community around these issues. So I think seeing that we have a lot of the same concerns is validating, helpful. And if you have something that wasn't mentioned that you want to put in the chat, I encourage that. So thank you to our panelists for our first two panels. Thank you, Siobhan, for moderating this last panel. I learned a lot listening to all of you, and certainly have lots of things to bring back to these conversations. We will reconvene at 1 p.m. for panel C on critical race theory in divisive time. For a month.
DJ, can you see and hear me?
I can see and hear you. Sure.
Yes, I am turning everything on now, so hopefully you can see and hear me as well.
Hi, Tiba.
Hey. I feel
Love this.
thwarted once again.
Love this background, D. This is awesome. Thank you.
I'm glad you like it. I was worried it'd be a little busy.
That's because we busy. That's what we do is busy.
We're gonna start off live, right? Our audience is here, just so you know.
Just
I want that energy. I hope you keep it.
Just quick question. Is the mic hot right now? I assume it is.
Mhm.
Okay.
How many we got in attendance?
Right now we're at 43, but it'll probably go up.
How many have we had throughout the entire symposium?
It's been consistently at about 100.
Excellent, excellent.
Down to about 85, I think is the low. But I think there are going to be some people logging back on because a lot of people clicked off after the last.
Did you see Areto says I'm not being seen. Please make me a
I tried
panelist.
to offer him to upgrade as a panelist a couple times, but it was too big.
It was too. He doesn't have the link.
I just tried to promote him again. Hopefully he accepts it. There we go.
Excellent.
All right.
Professor Makode, how are you, sir?
Doing all right, doing all right. Yeah, I heard you say you tried to send it to me a few times. I may have not been at my desk when you sent it, or it disappeared as soon as I came back. Because you know, it shows up and it disappears. So
It's all good. You were here and accounted for. How you doing, Loretta?
doing all right, doing all right. Excited about this. This has been a fantastic event so far.
I'm glad you're excited. It's been a good day so far, I think. So hope people are getting some nuggets.
Jamila says that she can see and hear us, but she does not see herself.
Okay, so let me see if I can find her.
Please.
I don't see her at all, unless she's under a different name.
I will let her know.
I will resend the invite to her. Bear with us one moment. We got a lost panelist.
She's going to log out and try to get in again.
That's what I did. That doesn't work.
Well, a brand new invite. I sent them twice today too. I'm gonna send it to her email directly.
So I'm going to read from this binder right here. We got like 3 hours, right?
Of course. For you, always.
Not on a Friday.
If it's good, we'll log off.
Right?
It's the Professor Omakwade show.
I'll just begin with complainants in this Florida case.
That must be a long, big binder if it's out of Florida.
Yes, sir.
If you all are communicating with Jamila, I just sent her the link again.
Okay.
Maybe she's not getting my email. Yeah, she's not getting it from me. I don't know if I'm typing it.
You are using the KU address, right?
Jefferson Jones at ku.edu.
Gotta be. She says that she literally, her quote is, "I have nothing."
I'm sending it to you to send it.
Okay.
Maybe my emails.
Technology.
Can you please add the background for me?
Oh, there she is.
It should come up.
Oh, show up.
If you just turn on your camera, it should be there already. We have a lovely picture of you.
No, I don't want to turn it on unless it's there because my background otherwise is really not something I'm trying to have on here.
And by the way, the mic is hot too, so.
Oh, I know.
But
Let's see.
it should be up when you turn your camera off.
It was automatic.
It's there. I see it. Thank you.
Well, our last panel, folks, we're very excited about because as we've said throughout the day, this is the second time we've come together around these issues. Around the same time last year, we held the 2022 Herff Symposium. So this year, we're attempting to bring those scholars back to engage in a discussion about their work since last year's symposium in their respective fields, where they will today probe whether there are new challenges to crit on the horizon. They'll also explore how teaching crit in law schools and more broadly has been impacted and how legal scholars and lawyers should address crit challenges. And there are now clear professional obligations for crit related topics in law school. Before we get started, I would like to initiate one last poll for today for those of you that have been with us. And this one is intended to just get a little bit of a sense of what schools, where we are in terms of how robust is our curriculum. And this is just a personal anecdotal rating. And after that, I will turn it over to esteemed moderator Daryl Jackson, who is a former colleague and dear friend, and also the 2022 visiting Herff Chair of Excellence and current associate professor at the University of Wyoming College of Law.
So I am Daryl Jackson. Good afternoon. And as Professor Frank introduced me, I'm professor of law at the University of Wyoming College of Law. And I was absolutely honored to serve as the 2022 University of Memphis Cecil C. Humphreys School of Law's visiting Herff Chair of Excellence in Law. It was an amazing time there in a vibrant community. And the discussion that we had earlier about online versus in person kind of goes to the moment now, where I wish those of you that haven't been in Memphis could visit the city, see the energy, spend time with the people, especially in this moment when so much is being asked of the community in hurt and in healing. I wish we could all gather together in Memphis to spend time together. I know that the online availability makes this accessible to more. So I appreciate that as well. But I wish we were there in Memphis together. During my time there, I got to know a little bit about the city of Memphis and Memphis law. But I think most importantly, I got to really get a feel for the relationship between Professor Frank and both the law school and the city of Memphis. And for those of you that don't know her, she has done much for Memphis law, and equally as much for Memphis, the city, too. I hope that each of you gets a chance to recognize not only all the work that she's done, but also the amazing resource that she is. I'm guessing many of you already know her, but for those of you that are just learning about Professor Frank today, reach out to her. She is a resource bar none. Now, welcome to what I hope will be a continuation of Memphis Law Symposium, analyzing the past, present, and future of critical race theory last year, or what we're kind of viewing it as today, CRT and its relationship with teaching bias, cultural competency, and racism in law schools. Just like last year, if you don't know what's going on across the country, and especially in many legislatures, take a moment to plug in CRT into your favorite web browser. Fortunately, Professor Frank and the earlier panelists have already provided us with a decent foundation for our understanding of ABA Standard 303. The goal of this panel is to provide you with access to information from scholars who have been reading, researching, and writing about these issues for years or even decades. As your program instructs, this panel will explore how teaching CRT in law schools, and more broadly, has been impacted, and how legal scholars and lawyers should address CRT challenges, especially when there are now clear professional obligations to explore CRT-related topics in law schools. So for the next 80 minutes, let's talk CRT. Let's push the boundaries. Do that, please join me in welcoming today's panelists. Atiba Ellis is a professor of law at Case Western Reserve University School of Law. Aredo Omakwade is a professor of law at Florida A&M University College of Law. And Jamila Jefferson Jones is the Earl B. Schertz Research Professor and Associate Dean for Diversity, Equity, Inclusion, and Belonging at the University of Kansas School of Law. We also had our friend, our colleague, Christian Sundquist joining us. He is a professor of law at the University of Pittsburgh School of Law, but he is taken ill, and by ill, I mean seriously ill. So we're asking for all of your positive prayers, karma, energy, whatever you can. Please, please, please send it towards Professor Sundquist and his family. They could really use your support and your encouragement and just your energy right now. So while Professor Sundquist won't be joining us in person, we will be thinking about him. He will be in our thoughts, and please keep him in your prayers. So I'm going to open our discussion with a common question for each of the panelists. And from that, I'm going to go to individualized questions, which are more geared towards their specific research interests. But to start with, for each of you, as you led your own panel in 2022, what was your theme then? And how is your analysis any different as we enter into 2023? In other words, what's changed or hasn't changed, for better or for worse, since we last met? And since I'm going to start with you, Professor Omakwade, when we re-enter into the individualized part, how about you start us on our discussion?
Well, thank you. Thank you, Professor Jackson. I want to also just sort of reiterate all the commentary you made about Dean Frank's efforts in creating this space since last year, and well beyond that for all the work she's done in Memphis. As far as our fundamental rights panel, that was the panel I moderated and was on last year. We covered health disparities in the wake of the COVID pandemic and also that preceded the COVID pandemic. We covered racial DNA genetics and racial science. We had a panelist who covered that. And my core area was focusing on the boogeyman of critical race theory, of CRT in education. Now, what's changed? Not a whole lot. in terms of anything that anyone will find like earth shattering. Some things have come more to the forefront. We've made some incremental progress. I'll give you one example of that in my core area, education. We have a situation where my colleague and the former dean of FAMU College of Law is the named plaintiff in an ACLU suit to stop enforcement of the Stop Woke Act, as it is popularly called. And just to give some very brief background for everybody here, Stop Woke Act basically shuts down the abilities intended to, and if implemented, would have at least chilled speech on issues of race in the classroom, whether it be in higher education or in primary, secondary schools. There was an injunction thanks to this lawsuit that was brought, and it was challenged when it went to appellate court, federal court, and there is currently an injunction that allows me to continue to do my job. Now, among other things we spoke about on the panel was this notion of what is a fundamental right. And while there is no fundamental right to public education, this is the focus of my research generally, the right to public education, as well as other fundamental rights and obligations of government. While there is no fundamental right to public education at the national level, enter the paradox. Each state within the United States recognizes some variation on a right to public education, where they're saying a right to high quality education or a right to adequate education, as is stated in Article 11, Section 12, I believe, of the Tennessee Constitution. So we have in Florida actually a high quality education requirement, which adds to the sort of irony, and that's in Article 9, Article 9 of the Constitution. You have the irony of requiring that we not educate on certain topics in a higher education space. One thing I do want to sort of put out there is to anyone who is interested in bringing litigation in Florida, one idea that is popped up time and time again is, well, if law is supposed to apply to everyone equally, then if the concern under the Stop Woke Act or it's implementing regulations is making sure we protect people from feeling bad about themselves, then very straightforwardly, our concern as people who study CRT is that the current and traditional models undermine the very people we're trying to teach, undermine anyone who's not white, undermine anyone who's not male, undermine essentially all those who have been othered traditionally. So the lawsuit that should be brought ultimately is not, well, please allow us to make you feel bad, white people or men or whatever else. The lawsuit should be brought is, okay, let's use this as a tool to empower everybody. Let's stop with the hegemonic teachings that have been set up to actually undermine the self and engage in a white supremacist situation where whites remain on top and you reify the existing structures of power. So ultimately, CRT is a structural critique, right? And at the level of primary and secondary schools, even at the level of even college in most situations, we're not getting into the theoretical framings. We're not getting into sort of deep critiques of structure. What we're doing is just literally teaching facts. So the idea you cannot teach facts about race to kindergartners or first graders or second graders, but they do observe race issues all the time, is to actually reinforce a notion that what is occurring around them is normal. Let me be very clear. Nobody walks down the street in a major city and doesn't see race. You see it in who's wearing the suits, who's driving the nice cars, who is begging on the streets. So to pretend as though the lack of not mentioning it means that no one's going to talk about it or think about it, all you're doing is just allowing society to do its worst. And that is not the role of any public education system. Inculcating values, inculcating societal values is the role of education. And that is a continuing project. As to the healthcare issues, that's hitting a little bit too close to home right now, given our panelist situation. As to what he was dealing with, which was racial genetics, and in the context actually of criminal law, the use of race, DNA, race, science. Look, there is so much going on in criminal law right now that I am going to defer respectfully to our most distinguished moderator to talk about some of the criminal law issues that are going on in Tennessee, but right now and elsewhere and abroad. But I do want to ask one question of anybody who's out there as you're putting stuff in the Q&A. The African American Studies curriculum in Florida, as you are aware, our good governor has pushed to not allow the AP to offer that in the state of Florida. And then we've had the AP since adjust what they are putting out there. And of course, they said very officially, it is not a result of what Governor DeSantis said. I'll leave you to make judgment as to how much of that you believe. My question for you is, anyone who's familiar with the Memphis situation and the Shelby County situation, Shelby County Schools took a bold step. And I want to applaud you all out there. Took a bold step last year of joining a pilot program that only involves 60 schools across the country to have African American Studies AP. So I'm just curious how that's going for everybody out there. And I'm also curious about any suggestions you may have as to how to push the envelope. Again, we have the lawsuits going. There may be some other non-litigation strategies as well that involve regulation. And I do not want to take up everyone's time on just my stuff. So I will pass the mic back to our most distinguished moderator.
I'll be circling back to you shortly. Professor Jefferson Jones.
Sure. So what we talked about last year on my panel, which was focused on property and CRT, Dean Tajania Henderson of Rutgers Graduate School and also professor at the law school there, and Jacob Wagner, who is the director of the Urban Studies program at the University of Missouri, Kansas City. We really looked at what's going on in the classroom, but also reframing issues for our students. So Dean Henderson talked about before Shelley, and her argument was that discussions about property and race must grapple with Black dispossession in the early 20th century. So giving historical context. And she said, and we also had to look at how it shapes cities and suburbs and losses of generational wealth and undiscussed trauma. So that was her argument. Professor Wagner talked about greenlining rather than redlining. And his argument was that basic evidence on racialization of neighborhoods, structures, legal, financial, et cetera, and spatial regimes of racialization. He looked at those and he talked about redlining as focusing on the so-called pathology of Black neighborhoods rather than the role of white folk, like planners, for example, which is his area. And so he wanted to focus on affirmatively undoing the structures that sustain Black dispossession and white privilege. And then I discussed really going more deeply into the use of CRT in the classroom, in the property classroom, but also outside of it with regard to CLEs and continuing education. And so we looked at the various students that are out there, not just our students internally in our schools, but our former students, or those that we didn't get a chance to teach who had the older version of property, right? How we get to them and have them reframe their thinking with regard to property and property rights.
Professor Ellis.
Well, good afternoon, everyone. I also want to join in to the thanks to the University of Memphis and to Dean Frank, and I want to join my colleagues in our well wishes to Professor Sundquist. So our panel from last year's convening talked about the twin aims of Reconstruction and how that long story of granting freed slaves political and economic rights was an ongoing foundational dilemma for American society. So my colleagues on that panel Dean Olympia Duhart at Nova Southeastern spoke to reading Shelby County v. Holder, the seminal voting rights case of this era, which dismantles Section 5 of the Voting Rights Act and has now created nearly a decade of havocs around the enforcement of rights for people of color when it comes to voting. She talked about that through the lens of Frederick Douglass and through the lens of his writings about reclaiming the right to vote or claiming the right to vote for freed slaves and its importance to the meaning of citizenship in as much as it spoke to the autonomy and equality of all citizens to have an undiluted right to vote. So in that sense, we spoke to political equality. And then my colleague, Professor Priya Bhaskaran at the American University Washington College of Law spoke to the economic equality through reflecting on her work around economic development and the work that she has done in her clinic and the need to engage in grassroots advocacy around these issues. And then I spoke to, along with having had the good fortune of being the opening panel that day, talk to the meaning of critical race theory as a theory that looks at the systematic and structural discrimination that is embedded in so many fundamental structures in American society. And then applying that lens to my particular specialty around voting rights and election law, and thinking a lot about disinformation. I was speaking in relation to the wake of the 2020 election and also January 6, 2021. And, in a sense, disruptive day, which from standard analyses, and let me take a second to distinguish sort of a standard analysis of the disruption of that day and the kind of riotousness that happened and the legal enforcement against that, which is fundamental in and of itself and important to speak to in terms of the stability of the United States. But I'm sure last year this time, I argued from a critical race perspective of that was a race riot. That was a race riot in the sense that you look at the substantive outcome of the 2020 election and how people of color turned out in not just states, but cities where they were the majority and pushed the result to where it rightfully was. And then we had this campaign of legal manipulation compounded by disinformation that ultimately led to riotous, insurrection that attempted to foment another civil war, if you will. What's changed in a year? Not much. So in this sense, from 2022 to 2023, we've seen another election cycle. And certainly it wasn't a presidential election cycle, but this combination of disinformation about the status of the election and questioning the worthiness of certain electors who tend to be poor and have melanin, this has continued and perpetuated and grown. It doesn't necessarily make national news, but we've seen in the 2022 election lots of episodes in Arizona, in Colorado, in a variety of places across the country, the sort of mushrooming of the election denial movement and folks claiming that it is impossible to think that the 2020 election, and yes, they're still hung up on 2020, that the 2020 election had the outcome that it had to have been something nefarious. And so rather than riot, rather than question, we now see the classic form of voter intimidation of, oh, let me just stand by the voting booth or just outside of the election center carrying my AK-47, and a number of these folks wearing their MAGA hats, trying to enforce election integrity by a gun. Or, as I have recently seen in my research, after the fact auditing of the election by, certain groups going door to door, asking people who they voted for, how long they've been a resident, becoming intimidating post hoc. And the irony, of course, is that our laws around election intimidation envision people being stopped from casting their votes. But I'm writing about the new phenomenon of people being intimidated over their vote, which obviously would have a chilling effect for the next election. So, and full disclosure, I not only am researching this, I was an expert witness in ongoing litigation about this, and I can tell you the details of that story in Q&A. But in some ways, where we saw the riotousness of 2020, we're now experiencing a wave of voter intimidation that reminds me of 1871.
I'm looking forward to you expanding on that, whether it's during the next segments or during Q&A, but definitely want to hear more. But before I move on to the individual questions, I want to make sure, did everybody get a chance to really talk about what's happening now? Does anybody want to add anything to it as we go into the individual parts? Because I appreciated making sure everybody who wasn't there with us last year got grounded in where we came from, but I want to make sure everybody knows where we're at today.
Yeah,
okay.
I would like to add something.
By all means.
So, this is an issue that hits close, and I'll try to continue to maintain composure. But our panelist last time, Rukaya Yerbi, who is actually the founder of the Institute for Healing, Justice, and Equity, as well as one of the co-founders of the Collaboration for Anti-Racism and Equity, spoke about health disparities, spoke very well about health disparities and the impact it has on all of us who are people of color, from maternal health to just falling ill and risking death over things that almost nobody can get hurt by. You never expect someone to be in the hospital over simple scrapes and scratches, but in a world where other concerns are oftentimes ignored, other concerns, background concerns, are never even checked for or miscategorized, or in a world where we simply are just not allowed to be comfortable to even enter those spaces. There's a lot of blame shifting that is actually blame shifting to the individual that is actually about structural racism that yields the result that's expected. So and again, that's something that hits very close to home for so many of us in the pandemic. Pandemic isn't over, but even beyond the pandemic, just even the most minor facets of life. And I struggle to give an example because there's one that just keeps coming to mind, but you all understand that we have a life or death struggle when it comes to these issues, and pretending that everything is fair does not make everything fair.
We don't have anybody really spending a lot of time on the health issues today, but I would encourage those that are in the audience to check out Dana Bowen Matthews' book on health disparities and this critical lens on the health system and its history. She's dean of GW, but she spent a lot of time researching this before she went into administration and even during the time in administration. And I'm channeling one of my earlier education professors in citing books every time somebody says something that I think is worthy of our time, but we may not have the time today to fully delve into. Professor Linda Mizell, I give you a nod today. The next phase is us diving deeper into kind of the specialties of our panelists. And Professor Amakwade and I share the education focus. My PhD is in education, and having done a lot of research in that area, one of the things that Professor Makwade spoke about was the research actually contradicting the legislation, right? There's research out there that students gained in outcomes in Arizona when they went into studies about ethnic studies, that the scores went up, thus suggesting you're enacting the laws in order to bring scores back down, right? That's the only logical conclusion you can have, because if you know the scores went up and you enact the legislation anyway, what other outcome could you be asking for? So as an internationally nationally recognized education scholar, Professor Makwade, since we're talking about how to teach CRT and CRT related topics, have you thought deeply about the pedagogy surrounding CRT and what techniques or tools we might have available to us as law professors as we teach about bias, cultural competency, and racism in law schools?
I appreciate this question. I'm actually happen to be working on an online Socrates project. There I'm seeking to put out there the appropriate use of online tools such as Zoom, which we're on right now, to reach a broader audience, but also to reset a method of education, particularly in law school, that has not really been updated in a meaningful way since, I think one panelist earlier said 1879. I think it was Terry McMurdy Chubb who mentioned that in the first panel. This Langdellian method of asking questions and getting answers is not inherently bad, right? The tool is only as good as the user, and the user exists in a social context. The social context of the Socratic method as it is today is a traditional one based in a certain form of hierarchy, racialized, gendered hierarchy that leaves out the other. So from a CRT perspective, I look forward to be able to use tools like this in order to educate folks in a way that, you know, takes out some of the hierarchical issues where you have the gunner who's at the front of the room. We all know in law school, where we have the person in the front of the room or in other disciplines who acts like they know all the answers. They don't really know anything more. The professors always know this, but the more you participate, the more you learn, the more comfortable you get. So you ultimately will, you know, so it's a self-fulfilling prophecy, whereas others will just sort of take their time and just sort of read, review, and by the time they get around to answering a question or having their really well thought out response, class is over, or they feel like everything's already been said. Now the online platform, this is something that Professor Sundquist would probably go into in a lot more detail if you were here with regard to technology, but technology doesn't cure racism. Technology doesn't cure any of the oppressive or privileged aspects of our society in themselves. But what I do suggest though in my work is that it creates an opportunity to set a new norm, to normalize things like cultural competency, right? Cultural proficiency was a subject that I believe on the first panel there was a great conversation about. So part of what I'm trying to do is update this discovery-based approach, because I'm a strong believer in discovery-based learning, critical thinking. And to go to your point, Dr. Jackson, Professor Jackson, critical thinking and critical race theory, right? Critical is core to it. Why would you want to get rid of critique? Now, critical race theory is deep and broad. You have to have understanding of facts and everything else. But beginning the process of critical thinking is ultimately what is going on here. Is what's going on at the elementary school level, at the high school level. And what the real project is to short circuit that. And for this, I'm going to sort of take you back to something I've written in the past about Black Reconstruction, looking at W.E.B. Du Bois's Black Reconstruction. In the South, the education system owes its existence to freed slaves. There was a belief before the Civil War amongst most Southerners that, hey, I'll get my education when I get money, when I have a position, title, power that necessitates it. What you're seeing here is something far bigger than just simply one racist over here or there saying they want to hurt Black folks. This attack on critical race theory is an attack on critical thinking, is an attack on the right to public education itself. And we need to see that and use this truth to connect with allies in other spaces, right? So Derek Bell's interest convergence can come to play. But I'm going far afield of the online Socrates project, which is this, to take this tool and make sure it's being used in a way that advances equity, that advances inclusion, using things like the chat feature, which, for example, which allows students to go back and forth and to talk amongst themselves during or after class using discussion boards. For me, every assignment that's submitted is assignment submitted on the discussion board. So students can share their brilliance and get rewarded for thinking through things, as opposed to just having an answer from their gut that they feel competence based on their privilege in espousing. These are some of the sort of the basic teaching strategies that in other fields have been normalized in some ways, but in law field, because we see ourselves as exceptional, hasn't been done. And yeah, I say that in other fields, but I'm not saying every other field, right? The sciences are even worse. Engineering is even worse when it comes to sort of privileging the already privileges I write about. So you know, we're not the worst. I don't think we're the worst, but we're clearly not the best.
So I for those in the audience that don't know, I get the chance to talk to Professor Amakwade a lot on the side as well. So while I had done the discussion boards in the past, I'd let them slip. But given our discussions over the near recent past, I've reinstituted them again. And so this semester, yes, they're doing exactly what Professor Amakwade is suggesting. I have students assigned each week to start the bigger discussion, and then other students get to pick and chime in. And it's what you said, instead of a gunner in the classroom, they get time to sit and think, and the amazing thoughts, discussions, debates that arise because they don't have to worry about the gunner, because they're in a safe space as they sit in whatever location and type this out, creates a whole nother dynamic that then often allows them to speak up in class because they've had the time to think through it overnight and they've written it out. And now they feel comfortable saying, you know what, I completely disagree with that position. And here's why, right? I love the dynamic, and I appreciate how much energy you put into these suggestions. Du Bois was the original crit. I still love that. He's one of the original crits, so I love citing back to W. Du Bois. And for those of you that are interested in what Professor Amakwade was suggesting about education, free Blacks, read Anderson. Anderson has a wonderful book about education in the South, and it's exactly what Professor Amakwade is suggesting, that education as a public institution is largely in thanks to Blacks who were freed slaves, who were willing to double tax themselves. They weren't willing just to pay tax, they double taxed themselves so that they would provide funding for their own kids to be educated because they knew the white folks in their community weren't going to do it. So much love to Professor Anderson. Again, I'm channeling you, Professor Mizell. I hope you're watching this. But as we move on to Professor Jefferson Jones, I think she knows I already have a lot of passion for the property interests, and critical race spatial analysis was one of my works where I touched into the area in which she's an expert. So Professor Jefferson Jones, as an internationally recognized property law scholar, how do you do CRT in your classroom? Why do you do CRT in your classroom? And I ask this question, especially recognizing that you are employed by the state of Kansas. And I'm guessing many of our audience would not think of the state of Kansas as the most progressive state in America. So how do you handle your business?
Okay, so I'm going to answer that question, but I'm going to back up a little bit. I had my hand up, but you didn't see me. I'm that person who is not the gunner in the classroom, and also who tends toward brevity. So I'm going to, but I had some time while Professor Amakwade was speaking to write down my thoughts. So I'm going to model what some of those quieter students should be led to do. So first of all, I do want to back up and Dean Frank for her invitation and for her vision, both for this and last year's symposium, but also for the time that she has set with me as I embarked on my role as a dean, as a DEI dean, and what she poured into me with regard to what I could do and ways in which I could structure that position. So I definitely want to thank her for that. I also, in talking about last year, did not get into the changes So I want to just say very briefly, in one way, nothing has changed, right? There's saying, plus ça change, plus c'est la même chose. The more things change, the more they stay the same. And what we see is this hardening of former positions, right? We also see the backlash. And one of the things about CRT, and this is a quote from Delgado and Stefanik, is that it considers the same issues that conventional civil rights and ethnic studies discourses consider, but places them in a broader perspective that includes economics, history, context, group, and self-interest, and even feelings and the unconscious. And one of the things that I am particularly interested in is history. And it's part of why I, besides my absolute love for her, work with Professor Tajania Henderson is also because she is a professional historian. One of the windows that I should have, or doors that I should have gone through and didn't in my education, and I'm not going back to school. I'm an amateur historian. But as we study history, especially with a critical race theory, we see that things are just happening over and over and over again. And so what's changed in the last year is both everything and nothing. We see the battle lines in this, as Professor Ellis had mentioned, in what to be an attempt to restart the Civil War. And we see a number of those themes repeating themselves with regard to Black progress and backlash against Black progress, racial progress writ large, and backlash against racial progress. So where we had a moment of racial reckoning, we now see that backlash, and it is in those sorts of things as the anti-woke and other anti-CRT legislation back there. So then we get to this idea of CRT in my classroom, the property classroom, both the how and the why of it. I'll start with the why. Part of the why is the lack of critical thinking that has been instilled in our students in their undergrad and particularly in their secondary, elementary and secondary education. We have had this very long stint of over-testing, which forces our teachers to teach to tests and takes away from them. And we have so many creative and interesting teachers out there, but takes a lot of the creativity away from them because they are forced into this over measurement regime, which does not allow them to bring in their own lived experiences, bring in their own passions, and bring in these notions of critical thinking and writing for our students. So part of it is because the students need it. And they need it because I, as a teacher of professional students, a teacher of students who will enter a profession, feel as though it is my obligation to make sure that I do not inflict upon the public a bunch of folk who cannot think. These are people who, as Charles Hamilton Houston said, are going to be social engineers. Well, I need them to be thinkers in order to be social engineers. And so part of what we're doing, and going back to what Professor Imakode said about this idea of critical thinking, and also just that word critical in critical race theory, I know that those who are anti-CRT have used that word critical to mean critical of white people, rather than thinking critically about the world, thinking critically about systems, thinking critically about whiteness. So not white people, but whiteness as a system. And so that is the why for me. So to get into the how, in a lot of ways, Professor Tate started explaining to you all in her property course some of the ways in which I also teach my course, which is, and I think she was talking about it in her tax course, but it's leading them to the logical conclusion. So I don't come in and say, this is what you ought to believe. I instead give them certain facts and introduce them to voices that they may not have otherwise heard, and let them get to their own conclusions. The truth of the matter is, though, I know that it can really only, if they are paying attention, take them in one direction. And that is not the direction in which I'm leading them. It's the direction in which the facts and the history and the context will lead them. So I start off, and I believe Professor Tate mentioned Johnson v. McIntosh. That's the second case that my students get. The first one that they get is Pearson v. Post. So those of you who don't teach property or haven't been in a property course in a long time, that's the Fox case, right? And so we do the Fox case, and we do it in the pretty traditional way. But we've been talking about theories of property and what's property supposed to do. So should we look to Lockean labor theory? Should we look to utilitarian theory? What are we doing here? How is the court making its decision? So that's day one. But then the next thing that I have them do is read Bethany Berger's It's Not About the Fox. So all this time, they've spent class time thinking it's about the fox. And she's like, well, what about the land? What about the people? And in order to do that, she must get into the socioeconomics of the people, who's new, who's old, what's old money, what's new money, what's tradition. And by the way, what's going on with the non-European people who are also on the scene. So she talks about free Black people who are there and Native people who are there. And so my students start to, just with that, open their minds. And one of the things I do when I give them excerpts of law review articles is one of my slides will always have a picture of the author. So with her, I put up this white woman who's having this conversation with us because I want them to see her. I want them to see the speaker. I want them to see other than just white male speakers. So I put her up there. And so we're starting to get into critical legal studies right there because they realize, and I tell them, hey, with every case, I want you to ask yourself a number of questions first. Where are we? And by where are we geographically? What year is this? What's going on in the country at this time? Don't just read a case. Read the case in its historical context. What is going on in the country? What's going on in the world? We then do move into, one of the cases we move into is Johnson v. McIntosh, which Professor Tate explained to you earlier, but it deals with whether or not Indigenous tribes have the right to transfer land to anyone, to individuals. And the answer comes back no. And my students are very good at seeing through the problems there, the language of calling Native peoples savages, the ridiculousness of Justice Marshall's saying, well, this is wrong, but oh, well, this is the country and the courts of the conqueror can't be expected to dismantle the fact that we have conquered this land, right? So, at that point I say, well, that sounds like Audre Lorde, right? And those who know, and those, but I go ahead and give them the quote. And, I say, of course, the master's tools can't be used to dismantle the master's house. And we talk about it from that perspective, but I then juxtapose that the next day their reading is actually ear listening. Because that's the other thing that I try to do, is to not have all of our modes of delivery be exactly the same, so I have students who may learn differently. So we listen to a podcast, and I'll put it in the chat in a moment. I have them listen to 2 episodes of the This Land podcast, and This Land is the podcaster is Rebecca Nagel, who is not a lawyer. She is a journalist. And she is a Native American woman, and she deals with issues of indigeneity. And in particular, what I have them listen to is about the McGirt case. So I juxtapose Johnson v. McIntosh with McGirt, and we talk about Indigenous rights and land. We talk about broken treaties and broken promises. We also, though I give no one any quarter, we also, though we talk about the Trail of Tears, we talk about the Black folk who are also on that Trail of Tears, those who were enslaved or were freedmen of those nations. And we talk about that, and we talk about the 5 tribes. So we get into all of those things, giving them historical background that I know they didn't get in their earlier education. And they tell me. I do remember one student who was one of my gunners in the front row, but a great one that I enjoyed. And he was always very, very polite, raised his hand, spoke in a way that took into consideration the thoughts and feelings of others. But when the first time I mentioned to him that the 5 tribes had enslaved people in their ranks, he yelled out from the front row, "Wait, I've been in school all this time and nobody's told me this." He did not disbelieve me. He believed me. We had that trust, but he said no one had ever told him. And my response to him was, maybe they didn't want you to know. Wonder what else you haven't been told. So part of what I'm doing from the beginning is setting the stage, setting this foundation, and trying to teach them to challenge what they know, what they thought they knew, and to challenge me, right? That is also part of it. So to think critically, so for me, that how and the how is in some of the ways I just explained to you, but the why is because they need to think, because they are going to be out there hopefully changing the world. And so they have to be very thoughtful in the way that they do that and in the tools that they use. You're on mute, Dr. Jackson.
Thank you. I have never taught a critical race theory class where I have not had a student come up and say, I didn't know this, and why haven't they taught this to me? Every single time, they want to know why the school systems have held this back from them. That's the beauty of these classes, is it's not about teaching an indoctrination. It's about teaching what wasn't taught and then letting them come to their own conclusions, which I regularly remind them. This isn't for me to tell you what to think. It's for me to push you to think and for make sure that you have all the data to make the decisions that you make. I wholeheartedly suggest everybody go out and listen to the This Land podcast, the one that Professor Jefferson Jones was mentioning. It's an incredible podcast. I'm waiting for her to put it in the chat so everybody gets it. We used it because, for those of you who don't know my other research area, it's called the Stealing Culture Project. And that's essentially what we're looking at, the issues that are raised into this Land podcast. And for those of you that teach other subjects like criminal procedure, since Professor Makwade asked me to speak just a little bit about criminal justice system, when you want to bring in other visual and audio tools, there's a wonderful clip from the Emory University about the Scottsboro Boys, which does what Professor Jefferson Jones was just talking about, puts it in time and place and pictures so students understand the nuances of what was happening and how it looked. Because the text on that book, that case book you have from West or whatever published, they don't bring out the nuances of what was going on when these cases are developed. So I highly encourage you, like Professor Jefferson Jones was suggesting, to use other tools to enhance the students' ability to digest and appreciate what these cases are really, really and truly about. Professor Ellis, you are clearly an internationally recognized election law scholar, having provided live commentary to the BBC during American elections. So how have you employed CRT as you analyze US elections, especially since our last symposium in February 2022?
Well, thank you, Dr. Jackson. I actually want to start this because I do want to get to sort of recent analyses and talk about some, among other things, rounding out a few thoughts about election deniers and voter intimidation. But I also want to talk a little bit about, as I'm sure you all know, and I'll tell you if you don't, about Moore v. Harper and yeah, I taught a little bit of critical race theory in my election law class just a couple of days ago, and taught about Giles v. Harris, and we can talk about that. But there's something I want to join in on with my colleagues. Both Dean Jefferson Jones and Professor Amakwade have been talking about education. And it occurs to me that it's worth saying that one of the ironies of the anti-CRT movement, what my friend and colleague and mentor Cheryl Harris, who spoke last year, I forgot to give her a shout out during our rewind, and in her lecture, she was making the point that this is really anti-discrimination as the theme of all this. We are against being against inequality, as it were, if you are taking the positions of those who have wanted to serve as thought police, as arbiter of the morality of race, as and one thing I've gotten interested in as policers of elections in such a way that the state itself becomes the vote intimidator. You know, I talked earlier about how, you know, private citizens are acting, but the picture is a bit bigger than this. But this tags to education, because in all the ways I've just described and inspired by my friends on this panel, it's worth pointing out that these are all ways of shifting thinking, of shifting perspective. It's the imposition of an ideology in order to shape decision-making to achieve power, right? And that's as critical race theory as you can get about these sorts of things, because it names what the game is, right? And this is in the tradition of Derek Bell, who I'm proud to work with, Professor Harris and my other colleagues, in order to, we are in the midst of reissuing racism in American law for a new decade. And hopefully we can convene again and talk about that when the manuscript is done. But again, this is about shifting thinking. And in this sense, this is about miseducation. And the essence of this, and the insight that my friends here have inspired me to say, is that on the one hand, critical thinking is necessary to a functional democracy. And we talk about that all the time, right, in civil discourse. But the thing we don't talk about is how all these campaigns to do miseducation and inspire disinformation are the necessary predicate for the endurance of white supremacy. It's the necessary predicate, the disinformation, the misinformation. And when I said earlier about how this is re-sparking the Civil War, I stepped back and thought about that. In certain senses, and I think historian Barbara Fields said this at one point during the Ken Burns documentary, The Civil War, she made the point that the Civil War never ended. As an ideological and educational matter, the Civil War never ended. The same fundamental debate about who is worthy to be part of the democracy continues. Now it has transformed and encoded itself, right? It's encoded itself in terms of election deniers who basically only want to certify elections if their person wins, is a version of this, right? It's an imposition of a regime that from its beginning, in its modern iteration, talked about who is unworthy in this society, and it revolved around people of color, immigrants, and the poor, right? And so it then gets excused in the sense of making America something other than what it is now, but in this sense, it's making it what it was, which is why it's hard for me to remember whether this is 2023 or 1871 or 1857 in terms of the ideological energy that's being provided around this, right? So we've seen this grow in a number of ways. And of course, my interests are about voter fraud, and I've already talked about voter intimidation, but it's also worth throwing in the whole notion of gerrymandering, right? And then now we live in, because in each stage, right, at the heart of at least the way I think about critical race theory and teach it, it is in each stage, there is a push-pull, right? There is an evolution forward, but then there's a step back. There's a success of winning the Civil War and restoring a new notion of citizenship and equality through the Reconstruction Amendments, but then there's a step back through Jim Crow and the sort of overtly voter intimidating people out of their ballots, right? Through formal and informal means, whether it's Jim Crow voter suppression, but then that gets struck down by the VRA, right? The new legal order, the actual interracial democracy gets created. It existed from about 1866 to 1877 in Reconstruction, then gets lost and then gets found again in 1965. But, and we could talk a lot about this, but we need to leave time for questions. We see the pattern of retrenchment and recalibration once again through the Shelby County decision, through the Brnovich decision. And worth mentioning, that pattern continues in the 2022 term. The court has before it Merrill v. Milligan, which is going to question the fundamental basis of how the Voting Rights Act can protect against racial vote dilution. In very, very short, the argument is, instead of looking for minority groups with political power who are trying to exercise it, but are getting frustrated by the majority, let's actually frame the question as, what should a race-neutral map look like? And it framed that way, the whole question of, is there a cohesive political community of people of color who are having their rights stymied through being washed out in the map, becomes less and less relevant. This rewrites Thornburg v. Jingles if the court goes in favor of the state of Alabama in this case, right? But then there's also Moore v. Harper, and the argument from the state of North Carolina that the independent state legislature theory should be adopted. For those of you who don't know, the independent state legislature theory is the argument based on Article 1, Section 4, Clause 1 of the Constitution, the Elections Clause, that says the state legislature, I'm paraphrasing, but the state legislatures may set the time, place, and manner of elections, except Congress can override certain of those rules by appropriate legislation, right? One way of reading that phrase, according to North Carolina, is the state legislature is the only entity that can set up the rules around elections, and except for federal intervention, no one can question that, including the courts of the same state. So what happened in North Carolina was that they passed a voter ID law. Yet again, they have kept trying for the past decade to do this. Ever since Shelby County v. Holder came down, they kept trying to pass a strict voter ID law. And time again, the courts have struck it down. This time, the state Supreme Court strikes it down for being racially discriminatory. The state legislature says, let's go to the Supreme Court, play the independent state legislature theory card, and have the state court not only be overruled, but they get out of the business altogether. And given what the Supreme Court could do, state courts could be out of the business altogether of ruling on elections. Now, there are gradations of this. You should read Carolyn Shapiro's work in this regard. But what it comes down to is, if you take the most extreme version of the theory, the only people who could rule regarding federal elections, and fact of the matter is it'll push state elections too, are the state legislature and the US Supreme Court. Now, what has the US Supreme Court done? Well, I just talked about Shelby County and Brnovich, and they have dialed back the Voting Rights Act, right? Between that and a decision that moves to the side state Supreme Courts as parallel arbiter of the rights under state constitutions and federal constitutions, then who's going to control elections aside from the legislatures themselves, some of whom are very progressive, some of whom are very regressive? The critical race theory move on that is to say, that's like Giles v. Harris. Now, if you don't know Giles, I'll take a minute to tell you about it. Giles took place in 1903. After the wave of racially motivated Jim Crow disenfranchisement laws swept across the South, starting with Mississippi in 1890 through to Alabama in 1901, Giles, an African-American, sued the state, basically saying the state is conspiring to discriminate against Black people trying to vote. And if you read the record of the 1901 Alabama Convention, which I have, they don't hide it. They do not hide it at all. They are open to say the point here is to get rid of Black people and poor people that we don't like. So they go to the Supreme Court, and then the US Supreme Court, speaking through the voice of Oliver Wendell Holmes, and now I wish I could do what Dean Jefferson Jones would do and put Justice Holmes' picture up. You know, in his voice, he basically says, this complaint doesn't make any sense and we can't deal with it. Sorry. Because if Mr. Giles is right and this system is illegal, it's null and void and there's nothing we can do about it. And if he's wrong and if it's illegal, then we would be enjoining state authority where we would have no power to do so. Sorry, thank you for playing. And oh, by the way, if it's a question of whether Black people should get to vote, that's a political question up to the state. And so what I told my students Wednesday was, how's the worst outcome under the independent state legislature theory and Giles v. Harris different? Is it different? But like you said, Dr. Jackson, I just gave them the interpretation and the data and let them reach their decision. But I personally would argue that this is a path towards authoritarianism, right? If it is like Giles in 1903, it isn't just a system that would dissuade people of color from voting. It's implementing the authoritarianism and the outright violence, right? We all know about all of the race riots, Wilmington, North Carolina, Tulsa, Oklahoma, across the United States, right? It's also worthiness as a constitutional value. No, you have the right to vote. No, you don't have the right to vote. And it's about a system whose highest rule is we want to do for ourselves, and those who get in the way will get moved, right? And that is the theme here. This is the concern that we have to stand up against. This is why we come together in these symposia to have these conversations. And my hope is between today and tomorrow that we inspire each other to go out and stand up against the tide, right? Turn that temporary injunction into a permanent injunction, Professor Amakwade. Keep teaching those classes. Tell them about Johnson v. McIntosh, Dean Jefferson Jones. Dr. Jackson, you tell us about how the criminal law does not do disservice. And for all of those hearing me, all of you, find your critical voice and speak that truth, because that truth will rise. And I leave you, with that thought that if we are intimidated by today, we can win tomorrow.
Apparently, Professor Frank has informed me that with our 10 minutes left, we have a wealth of questions waiting. So I am going to open the mic to Professor Frank to throw out some of the questions. I don't think we can get to them all today, and I think this is the call for yet another continued symposium in the near future. But Professor Frank, what would you like to throw at us?
I think Professor Ellis is very eloquent and call to action at the end there is a good start to an answer to the first question. And this question actually came from my panel this morning. So I promised we would try to get it in at some point today. And it's involving the divisive concept bills. And in states like Tennessee, we have a divisive concept bill, but luckily in Tennessee, we have an accreditation exception. If you're in a place where there is no accreditation exception, and this may be for you, Professor Makwade, that, well, maybe, how are you dealing with that in these places with no accreditation exception?
Well, it actually connects, that particular question connects very well with something I wanted to share with you. So I'll just share it really quickly. This is a list of the state's legislation restricting education. Add to that some of the concerns about divisive concepts. You can see Florida literally bans divisive concepts. We have Alabama, Arizona, Florida, Tennessee, Texas, just one list. How do you deal with it? Well, you mentioned 303 is sort of a shield. Some other states have done even better. State legislation broadening education, literally requiring discussion of roles and contributions of ethnic groups in California, requires Black and Latino studies in Connecticut, requires history and culture, slavery and economics, segregation and the law education in Delaware, requires history and culture, slavery and civil rights, socioeconomic struggle in the state of Illinois. This is how we deal with it. We deal with it by not being defensive, but going on the offense in favor of high quality public education at every level. And you see with the ABA, I mean, there was a question that was asked, well, what's the ABA really trying to do here and everything else? I mean, they're doing what we pushed them to do. My belief very strongly is that 303C has potential, and we need to continue to breathe life into, like any other administrative regulation. There is a possibility for industry capture, and there is a possibility for something far greater. Let's push the ABA. Let's push. So 303C in this context gives us space to at least have some space as law professors, but it can't stop there. So in response to Professor Ellis's invocation that we push to do more and make it a permanent injunction as opposed to a temporary one, and to move beyond that, and I would suggest moving beyond that and making a mandate. We get these 303Cs across accredited bodies, right? We use, in the Southeastern Association. So you have SACs, right? The South, you have different accrediting bodies in different areas of the country. We push those accrediting bodies to include some similar language in different contexts. So it's not just the law school is protected, because if you're standing alone in your institution with this sort of institutional protection, it's eventually going to erode. So that's my response, is that not just that we push for it, but we actually look to the models to know that it is actually possible out there. It is possible to actually craft something that mandates it. And also my earlier statement that it's probably unconstitutional under the state constitutions to literally bar these discussions. And we get back to democracy and education. It's always troubling to mention Dewey on some level when it comes to racial equity, but democracy and education is literally a title of one of his books, right? And the idea here is that you don't have democracy without education. It leads to demagoguery ultimately. It leads to a form of tyranny. And I just love the idea that of Cheryl Harris's statement that you're going to be anti-racist. I mean, but we've seen it already. This is one of the issues that we talk about in critical race theory all the time, or at least some of us have been. We need to get away from using acronyms, because being anti-Antifa almost makes sense. To be anti-fascist? Are you kidding me?
Let me jump in to add on to Professor Makwade. And Professor Makwade, can you go to the last slide? Not this one, but the one before that one. What we're talking about is bills, as Professor Makwade has laid out in the slide, restricting education. And one of the things that, as a PhD in education and talking to Professor Makwade about education, I am encouraging other law professors to do, since as has been discussed throughout this entire symposium, we are in the education field. Think about attending AERA, the American Educational Research Association. They have their big convention coming up soon in Chicago, and our joining with them to think through and discuss these issues would be extremely helpful. They're often looking for more help from lawyers, and lawyers are often looking for more help. Lawyers and law professors are often looking for more help from the education research arena. So I have gone to AERA many other times before because of, again, my background, but I am encouraging other law professors to join me in going to this conference coming up in Chicago or ones in the future, so that we're in dialogue with them about these issues. As Professor Amakwade pointed out, and I'm kind of encapsulating the wording, I may not be hitting it right on, but a lot of this legislation has to go with making anybody who feels uncomfortable, right, have this out. And so one of the things educators have done, and this is kind of going to Ian Haney Lopez's ideas of turning kind of a ninja on this, is they're saying if that's the case, that we can't make anybody uncomfortable, we need to have our legislators in front of everybody as we confront the fact that we can no longer teach biology. We can't. We have to stop teaching biology because you said we can't make anybody uncomfortable, and there's many deep-held foundational religious belief citizens in our community and students in our schools who believe in a different form of human creation. And so if they're going to feel uncomfortable, we have to stop teaching biology. And all of a sudden legislatures find themselves backtracking because you said I can't make anybody feel uncomfortable. We can go down and down and down the list of books and theories and disciplines that we can no longer teach in our school system, because if anybody feels uncomfortable, we have to stop teaching it. Unless, of course, you mean what Professor Ellis suggests, white people feel uncomfortable. If that's what you're suggesting, then we have to force them to say it. And that's the only way we start to create kind of the sword and the shield metaphor that Professor Amakwade was suggesting.
I do want to take one other question, at least. And before I take the last question, I just want to mention that you may have heard over the course of the day that participants, our panelists, our speakers, we're all participating, many of us, in a working group tomorrow. And so some of what we want to do in that working group is further explore some of the questions we get today where we don't have a lot of answers and we haven't talked about collectively, because it takes more than one mind to think through some of these issues. That's what tomorrow is for. So if we don't get to your question, it will be raised in our working group session tomorrow. And also I'm going to remind everyone in a moment to register if you didn't already, so that we can get back with you with the results of our working group. So the last question that I'm going to throw out here, because I think that a lot of people may have this question, it goes back to what we were talking about in terms of these divisive concept bills and how this may be stifling faculty speech. And also how has it changed, if anything, how we're teaching? Should it? And I would just throw that as a general concept out there, because we've got a couple questions, I think, today that hit upon this fear around the divisive concept bills and how that might be stifling faculty speech, especially when we have this mandate now.
Anybody want to jump off on that one? I'm happy to start the discussion, but part of my initial entree into these bills was when the former president, not the current one, the former president put out the executive order. And my brother does a lot of federal DE&I, or did before he retired. And so one of the things that I did, and I encourage others to do, is get the exact legislation as it's written, right? Read through it and break it down. Really assess what the legislation says word for word. And the reason I say that is, as he was concerned about it on the federal level, given the prior president's executive order, I read through it and said, look, I don't know specifically what you do, but the way I teach CRT, violates none of the language that's in this order. And it goes back to what Professor Jefferson Jones says earlier. I teach the facts, right? And you know, Professor Frank, the theme of my class at your university, at your law school, was show me the lie. Show me the lie. If I'm teaching something that I can show you is in the Constitution, show me the lie. If I can teach you something that's in the case law, as Professor Ellis just showed, show me the lie. Like, I encouraged them to bring it to the legislature. Show me the lie. All I'm doing is showing them things that you did not show them before. And the question becomes, why didn't you show it before? Why didn't you discuss this case before? Why didn't you talk about this acting before? All I'm doing is raising things that they did not see before. And then I let them come to their own conclusions and their own decisions. So if you're telling me you don't want our students to think, say it in public. If you're saying you don't want them to see the facts, say it in public. Like, that's how I've approached any act, both federally and state. Anytime I've seen a woke type, stop woke type act, is look at the legislation, break down the wordings, and then think about actually what you do in your own institution. And does it actually violate any of those words?
I'm trying to tender it to you to moderate your own panel, but we kind of switched some roles here. So Professor Mekwede, do you have anything to add there?
Yeah, I want to add an acknowledgement of the challenges that this provides. I've seen a few different messages here, just asking this question of how do we stand up? How do we ask these? How do we push for equity in a place that's hostile? And I want to first of all acknowledge the challenge. You are risking your life. You're risking your job, right? You're risking your job even with tenure. We're seeing an attack on tenure. I mean, there's a whole list of things I was going to go over with regard to what is going on here in Florida, even after the injunction in higher education, attempts to put out there who's teaching what, how much they're being paid, everything else, in a plan to sort of chill speech and everything else. So I want to be very clear about this. There is a risk. People, generations of people have died to get us to this point. Your job, your life is important. I'm not suggesting otherwise. I'm just saying if you're in a position to maybe be a tenured professor or someone who has a really great situation and what you're risking is your job in a particular place that's hostile to you, perhaps, again, it's a personal choice, we take that risk. And the way we do that effectively is by coming together in community. The way we do that together is gathering together. So, all of us here who are on this panel have gathered together in the past, right? Some of us gather together incredibly regularly, especially in these pandemic times. So I guess I'm sort of shifting the focus a little bit away from sort of the pure law response into the community response. But I think I see those two things as linked if we're ever going to do this successfully. We need to come together collectively and use our collective power and strength to support each other. There are folks I know who actually were at risk in the midst of the Ferguson riots years ago when they were being targeted for being involved in Black Lives Matter, who are now have become transcendent international figures, in part because they had the support of the community to know they can boldly go forward. So that's what my suggestion is: form your community, lean on your community, but some of us have to be willing to take some risks. I'm taking a risk right now being on here. I accept that. We've been joking around offline about the risk I'm taking, and I want to just put it out there that anyone who does this work is taking a risk at a certain point. And to those junior faculty members out there who are struggling to figure things out, I urge you to get involved with some people, conversations with people outside of your school to give you some of the very straightforward perspectives on how to implement these things. One thing I remember earlier was get yourself a good casebook that makes the arguments for you. Integrate this stuff into your full conversations in your classroom, as opposed to trying to bring it in as a separate thing. That gives you a little bit of intellectual cover from the students. So those are a few of my comments. I have a lot more to say as we continue the working group later on. Oh, by the way, having the symposium at the end of this month, February 24th, and many of us here on this panel are going to be on that, except our Dean Jefferson Jones is actually going to be the keynote of that.
So I want to jump in there really quickly to piggyback off of what Professor Mekwede said. Yes, we need to be willing to take risks, but some of us are in privileged positions and ought to cover those who are not. So those of us, so I'm a full professor and I take that very seriously. in that I can cover my NTT folk, right, who are in the building, those who are non-tenure track, those who are on clinical, who have clinical tenure, which doesn't necessarily give them the same sort of protections. My LRW people, lawyering professors. And so I can say things that they can't necessarily say. They may say them to me, and then I'm going to go ahead and carry that water because I am more protected than they are. So it's also important to be aware of the hierarchies and to use what power you do have to protect those who have less power than you.
And then
So-
Professor Ellis can probably close us out.
I will say briefly, because I know I have to be told that. And my fellow panelists are laughing a little too much at that joke. But I also wanted to expand the lens a little bit, just because in preparing for this panel, we were having this exact conversation, and especially knowing that the other the prior panel addressed this head on, but we were getting into this conversation of what are the risks for faculty in particular. And a point I observed was that even if you're not directly subject to a bill of this sort, because you're at a public school, but not in a state where these bills have been passed yet, or you're in a private institution, there's still internal pressure that can be created that could have the same kind of effect on someone, right? And that given the layers here, you might be junior, but then it becomes a problem when you get to tenure, or you even might be senior and you do all of these things, and there are fates different than getting fired that can feel just as bad, right? You get shunned, you get isolated. But this gets back to Professor Omakode's point, right? Being in community helps empower all of us and helps connect each of us in ways that we can be of help to each other. And I mean, we can say more about it when we're talking tomorrow, but I think also the reality is, to put it very briefly, institutions show their priorities by where they spend the money, right? Because I have seen institutions, public and private, who say one thing, but they spend the money on something else. And so their real priorities come out in that sense. I've taught public, I've taught private. That has been true around both things. The difference is in public institutions, the legislatures can loudly call the rules, but in private institutions, it might be the trustees, it might be donors, and they might be invisible to you, but it's still the game. But we as a community can help us figure out how to play this chess and be responsive. So this brings us all back to thank you, University of Memphis, for spending the money to help this conversation take place, and let's keep talking.
I think that was an excellent way to end, as only you could, Professor Ellis. And I want to thank everyone today, all of our speakers, and especially Dean Henderson and Professor Jackson, just so everyone knows that they helped pick the panelists and topics, and I didn't have to do much. They knew just what to do. And so that was awesome. And thank you all for engaging in these conversations. As has been stated, tomorrow, many of our speakers are getting together for a working group. We hope to update you on what comes out of that. And so again, if you have not already registered, I will throw that registration link in the chat once again. And I also want to thank the trustees of the Herff Trust for the University of Memphis, our Dean, Catherine Shafson, my research assistant who has been fielding things all day, Penelope Brooks, and also our faculty who participated in our Cultural Competence Teaching Fellowship last year, and everyone who has served as a thought partner to me or any of our speakers over the years in doing this work. I appreciate you, I thank you, I honor you, and I hope to collaborate with you in the future.
You're muted, Dean Frank.
I said I'm taking screenshots of the polls and things of that nature for tomorrow. I was trying to figure out a way to just kind of separate the attendees from panel, and I can't. But I am going to send a link in a moment. If
BJ, you were on mute.
Is there a way to capture all of the questions?
that's what I'm doing now.
Just